All right, we're about a minute early, but I think we can get started. Calling our meeting to order of the Massachusetts Gaming Commission on June 26th. Excuse me. I think we did review the minutes for June 19th No, I'm sorry, they haven't been
distributed. Those are a work in progress.
Right.
They'll be
Okay.
distributed shortly, and we'll approve them next week, Mr.
Okay,
Chairman.
right, good. Administration, executive search update, Commissioner Zuniga.
Yes, thank you. We are in the process of interviewing the 4 firms that we selected for interviews, the 4 firms that responded on the executive search firm. We are halfway through that process. We anticipate that the last 2 interviews are scheduled for tomorrow, and fully anticipate that I will be coming back to this commission with a recommendation by the next meeting. After tomorrow, I will finalize my memo on recommendations, and will be coming again for approval. There are a couple of questions that I want to pose that started just to come up relative to the next steps that I think we should at least think about. And one of them has to do with the interface and the profile of the executive director for this position. How is that director going to interface with this commission? Clearly, I've explained that as per the statute, this commission hires that executive director and serves at the pleasure of this commission. But these questions have come in the context of how the organization is going to be structured, which I know our consultants are also working on that. So it's a little bit timely that we start thinking about it. And also a couple of other notions. One of them, for example, we have said that we want a gaming experience on the individual, but we probably need to clarify as to whether experience in the regulatory arena as opposed to industry is what we really mean. Or whether it's irrespective of where that experience may come from. So just another provocative question we've had was, would we be looking for a leader or a manager or a combination? And these are good things to start thinking about relative to the upcoming search. So I just kind of pose them as an update. I also want to have us start thinking about the next step in the process. Who among us will be project managing the executive search firm? I don't want it to be just assumed that it would be me because I was given this task of conducting the procurement. So I kind of also wanted to bring that up as a topic for discussion. But we can take it now or not. I just wanted to give those.
Well, I have a little bit the instinct that this is so important. We want to make sure that by the end of the day next Tuesday that we are moving forward. We have our choice and we can authorize them to get going. So if maybe it's worth spending a little bit of time now about some of those issues, certainly to see if there's any significant decision making, but just to go through them. I'm not sure what you meant by how we want to relate to the first issue that you put out there, the organizational structure and how we relate to the person. But I think certainly from my standpoint, we're looking for a very strong CEO of the Gaming Commission. I very much see myself as chair of the commission, not as anything remotely close to a part of the executive leadership of the entity. So very broad management skills. We're going to talk about the bureau. I think our preliminary conviction is that everybody in the agency except the commission and the commission's direct staff, like Janice, would report to the person. I think presumptively we would clearly want regulatory experience, administrative. We're talking about somebody who knows how to run a gaming regulatory agency. That's the most critical variable that there is. Now, there can be exceptions, you know, I wouldn't make it, I mean, if there's some home run person, we can think about it, but as to parameters, I would say that's absolutely a presumptive precondition.
Yeah.
I can speak to that also. I think in wording it, I think sometimes what is helpful, so you're not precluding other candidates, is to say that regulatory gaming experience preferred. And that way, candidates understand it's preferred, and if someone still thought they could, you know, come to the top without that experience, it certainly we'd take a look. But I think if you say preferred, you don't preclude other candidates, but yet you're letting it be known that that is the preference. As far as your question about a leadership or a manager, certainly this would be the leader of the organization as far as management of all those folks. Now, I think the best leaders, certainly they inspire, they get others to follow, but they also have great management skills. So in many ways, I think it's not either or. It is a leader that possesses management skills. So I think that's the way I would look at that in those two questions that you posed.
I agree with that as well, but is part of whatever the search firm does going to be to put together a challenge document or a job description or something that we all get a chance to talk about before the actual posting occurs?
Absolutely, and that's what I was perhaps alluding to. At least the two firms that we've interviewed, actually everybody on their responses articulated an initial period of fine-tuning the job description and the profile of the individual. And because that's really the immediate step after we make a selection, and because we all need to move efficiently, these are some of the questions that started to come up that I figured it's important to start considering. You know, just affirmation that the gaming regulatory piece is preferred, but of course there's many factors and aspects to any kind of these types of positions. But I also wanted to go back to the next steps for this commission. I mentioned I did not want to assume that I would be the one project managing this process. Perhaps this is an opportunity to go back to an initial assumption that Commissioner Stebbins would be part of that, or whether we have made have additional thoughts as to whether one of us or I would continue doing this process. But I wanted to make sure that what my task was in conducting this procurement, which soon will come to a conclusion with the recommendation, would be picked up quickly after when that happened.
I'm more than happy to become back involved in this part of it, either as one member of the commission or with another commissioner's help, but to kind of keep moving the process along. The question about I just want to pick up on what Commissioner Cameron said. We are in a sense looking for a leader. There isn't anybody. We're not having somebody who's stepping into an existing organization. We're having somebody step in who's got to help build the organization. And I certainly see staff development as a key piece of that. I mean, I think in some of the outreach we've done and the people we've talked to about initial positions, there's a lot of talent there. There's a lot of talent that, again, hasn't had experience in the gaming industry or even the regulatory side of it. But certainly some people who I think can be nurtured along as we kind of refine positions, change positions. Somebody who might be a jack of 3 or 4 trades suddenly falls into a category of one position or series of responsibilities. I think having a leader who can kind of pick those skills out, just not manage a process, but help us build a process and help us build a team. So, that leadership quality is key, I think, as we go forward.
I'm not sure that there's really a distinction here, but in a way, I think we have a lot of leaders. You know, we have a lot of people who have had very senior leadership positions, almost all of us, really. In a way, I kind of, if this is a meaningful distinction, I kind of think we need really great manager first and foremost, you know, almost a really super project manager at a high end who understands the regulatory business, who understands the gaming business, and really knows how to make the trains run on time. There's really a good systems person, you know, really a good, you know, performance review systems type person, you know, who really knows how to put, you know, it's I think of it as, to the extent that you have to err on one side or the other, we don't need, you know, we don't need spiritual leadership. We don't need team building. You know, there's a lot of stuff that we've got a lot of people that know how to do it, and our presence is we're gonna be the five of us still floating around. So, I really think we want a very, very capable, professional, trained, experienced manager. Now, by definition, they'll probably end up having leadership skills, but that's my instinct for what it's worth.
Well, we have our consultants pulled together kind of an initial job description for us to probably build off of and work off of as we proceed to the next step. But it's certainly something that would involve everybody's buy-in and sign-off before we go to the next step of posting the position.
As far as who ends up project managing, what does that mean exactly? Once we make the decision, how do you define what needs to be done?
Well, just to state the most basic of who would sign the contract with them and would be the point person for the day-to-day, for either the reporting, scheduling, et cetera. In the case of our consultants, you, Mr. Chairman, are that person. I just wanted to give that a thought as we move forward. Again, I'm more than happy to do that myself if that's assumed, but I just wanted to bring that up. If it's a good way to involve another commissioner and comply with all the open meeting rules, I think it's worthy of considering because it's such a meaningful search.
I think that for this one, this is really our most important hire to date, certainly, and probably will be the most important hire we make. And we ought to deal with this in the more formal route of creating a subcommittee to work on this. And
that requires public meetings?
It does.
Yeah.
But they can be an executive session for the preliminaries, records are kept, and a whole series of formalities that I think we ought to deal through, and I'll try and outline those for us for the next week after consultation with our attorneys. But I preliminarily consulted with them, and they're of the same opinion. So I will be prepared to prepare an outline and move forward with that. We'll recommend that next week.
I just have some concerns about that route. I think that candidates, and I think one way we may be able to manage this is to have advisory group assist us with this. I think that the candidates will be looking at, all have other jobs, and would be very concerned that that information would be out to the public. And I really have a concern about us not having the strongest candidates in the mix if we handle the entire process that way. I really have a concern about that, and I think we should consider it.
But the process doesn't envision everybody being out in the public until you get to the finalists. The one or two finalists who emerge from the pack are the only ones who would be out in front. But there are a number of other formalities to follow through and to go through, and the interviewing process done and can be done without having people exposed to the public view until the finalists emerge.
So for us, we could set up a subcommittee but still, and in order that we had the record keeping of, that's
Right.
required by public meetings and so forth,
Right.
but we could also have that subcommittee be the initial screening group. They
Right.
could do preliminary interviews,
Right.
and those would not have to be public
Right.
interviews.
Right.
Right, and as long as,
I mean, I need to work through the
Yeah,
details
okay.
of that, but
But that's the
a
intent.
that's the basic protocol and a basic approach to follow.
It was my understanding, and in interviewing a couple of these search firms, they look at their responsibility as all the initial screening and all that initial work, and then it would be their responsibility to bring a couple of finalists to the commission.
One can structure it in a number of different ways, and certainly the search firm's responsibility is to go out and beat the bushes to get a pool of the most highly qualified candidates, and one can ask them to bring back X number of people to interview. And the ones that I've been involved in, they brought back, in one case, they brought back 10 in that case, the full search committee interviewed. One can do it in a variety of different ways. But the ultimate point is that until you get to the finalists for the commission's decision, whether it's done by the search firm or by a subcommittee or some other way, only the finalists are the ones that appear in a public session. So we can manage it that way. And I think we ought to do this one with the formalities that attend this kind of a search.
and, the history, the UMass search,
And-
that went off the tracks is one that people will remember that and be looking at us to make sure that
Right.
we are. So, the issues would be the confidentiality issue that Commissioner Cameron's raising, and speed. I think
Right.
those are the two things we care
Right.
about. But if we can do the more formal process without compromising those two things, I think that's a good way to go. But let's hold this until you can put together a plan. I do think if there is going to be a subcommittee, formal or informal, that is going to do any preliminary screening, usually there's a search committee. The search firm brings people back to the search committee, and the search committee interviews some number of people, and that gets winnowed down to finalists. Whether we're going to have a search committee that plays that role, and I don't think we haven't figured that out yet.
Well, that's what I was talking about, the subcommittee
Right,
role
right.
being.
But Commissioner Cameron was saying, do we really want to do that? And
Well, I understand
I don't
that.
know. So,
I had a question. So you're talking about folks that are not commissioners? You're talking
No.
about an advisory group?
No, I was talking about a subcommittee of the committee. It could, of the commission. But it could include people outside the commission too. But a subcommittee has a certain formality and certain trappings of formality that it has to follow. And it is the UMass search that I had in mind, and
Right.
be happy as part of this package to circulate to you the letter that I have in the wake of that, just so we can see what the steps would be helpful to take.
and this is one that you wouldn't have been familiar with this, but it was one where the Attorney General severely reprimanded the president and the head of the trustees of UMass for doing a search which breached all the public meeting and made it look as if there was sort of an inside deal. It was bad story for UMass. And people are going to be sensitive to that. So we're going to have to mind our P's and Q's on this one. Anyway, so we can talk more about this when Commissioner McHugh's had a chance to tee up a recommendation and then make a final decision. But I think we know what the issues are. And we can, let's wait until next week to we can make a decision. I think the idea of having a search committee that has some people from the outside is kind of a good idea. That might be worth thinking about.
I do.
Right.
Okay, so we'll tee this up again on Tuesday. Anything else on that?
Nope, no, it's
And,
really just,
As far as who signs it, I don't think that makes any difference, but I think, who chairs the subcommittee?
Who
If
chair-
we have a
yes,
subcommittee,
that's
is
right.
really the question.
that's the question I was.
And it's, I half think maybe that should be the chair.
That could very well.
But I'm open to discussion on that for sure. Additional hires, we now have 3 in the pipeline, I think. We're right down to final drug testing, I think. We are hopefully within minutes away, or days, hours away from being able to announce a Director of Administrative Services, a receptionist, and an executive assistant, all three. But we're not quite there, and we have agreed not to make anything public until everything is finished. But that's coming quickly. Anything on discussion of internal policies? Do we have?
Well, the update is, since last week, Commissioner McHugh has given me some good and a number of comments on the draft that I put together, and we were looking to sit down and go through them perhaps as early as tomorrow. Is that?
Yes.
So we're moving along on making good progress on that employee handbook.
We hope to have that done in the very near future.
Right. Great.
One other internal policy that we should think about, particularly in light of next week, is that under the open meeting law, one can have absentee participation. There are three criteria, five, I think, criteria that permit somebody who's not present to participate in the commission meetings. That there are various requirements we have to follow in order to do that. Number one being that the participant's voice has to be audible, which is a pretty fundamental requirement. But in order to do that, we all have to, or the commission has to vote to allow absentee participation. And we do that as a one-time matter. And then if the criteria for absentee participation exist, one of which is a commission member being at some geographical distance that would make it impossible for him or her to attend, then the presiding officer at the hearing simply says that that's the case, and you move forward with the absentee participating by telephone. So in order to set the stage for that and have in place the foundation, we need to do that when and if the occasion arises. I'd move that the commission authorize the commission, ourselves, to allow absentee participation under the criteria that the open meeting law permits.
Second?
Second.
Any further discussion? All in favor?
Aye.
Aye. I mean, just a quick question. Do we have the capacity to do that in this room?
I'm not sure whether we.
Do we have the capacity to do that here? Oh, there we go. All right, good.
Closer? Sorry, yeah. I won't be here next, well, actually, our meeting's gonna be Monday, right? We've just, yeah, so for anybody who's a regular watcher, because Tuesday is the day before July 4th, we are moving our meeting to Monday, this location, same time, right? Monday, 1 to 4. That would be July 2nd, I guess. I will not be here. I will be calling in. I am mandated to chair, but I can designate another chair, and I think since I'm not going to be physically present, I think I'd like to designate Commissioner McHugh, the secretary, to be the chair that meeting.
All right.
If that's okay with you. Okay. We have a ton of meat this day, so let's get to it. Racing division, status report, et cetera.
Okay, just a few updates. We have put a financial oversight plan in place where there are approvals at management level of DPL and the recommendations for me to make final approvals. We talked through that process, and we are comfortable with that approval process for paying the bills, the expenditures. Secondly, we are continuing to work on an ISA for fiscal year 13. Just a couple of legal issues that we're working out there to make sure we're proceeding in a smart manner.
This is for the transfer of the monies?
Yes,
back
and
forth? The general operations?
The general
Same thing, yeah,
operations,
okay.
exactly right. That at the end of June, that the new fiscal year will take place in July, so we are working on that, and that will be done before the end of the year. And thirdly, I did hold the Gaming Commission's Racing Division first meeting/hearing last Thursday, in which we took care of some routine track matters, and there were 3 appeals of which I presided over, and I will have recommendations for the full commission at next week's meeting. We're preparing determinations this week, and I will have recommendations next week on those 3 matters. And that's all I have to report, Mr. Chair.
Have you rescheduled our field trips yet?
We have not. The Chief of Staff is in charge of field trips, and we have not rescheduled at this point. We will be doing so.
Just don't do them when I'm on vacation.
I know.
Okay. Project work plan. First is the ongoing notice of proposed wheelmaking. Anything, this is now, we've invited the public to comment on the regulations that we will be issuing about the first phase of the RFA, the request for applications. And even as we're drafting regulations for the request for applications, we're asking the public and participants to comment on that. Anything going on?
We've had 2 comments thus far, Mr. Chairman, both helpful from individuals who are not part of the industry. The period for commentary remains open for another couple of weeks, and we very much look forward to receiving additional comments. The comments are on the concept at a high level. Is the bifurcated process a good process? What things should we keep in mind and think about as we move forward with the rulemaking to implement it? And so the public is invited to make comments, and we look forward to receiving them.
Great. Consultant status report. Gentlemen. Introduce yourselves to our audience.
Guy Michael and Carol. Bob Carroll, Michael and Carol.
Michael and Carol. Michael and Carol. Okay. Michael and Carol from Michael and Carol. Welcome.
Yes. Thank you for inviting us to report on our various activities. I guess the first order of business would be to report to you on what we've been working on and how far we've come in some of the various areas. Over the course of the last week, we have delivered a number of different documents to you, some memoranda that we will be discussing later on in our presentation here. We've also been meeting with members of the Commission and various agencies to discuss memoranda of understanding that may need to be or will need to be engaged in between different agencies. We've talked about table of organization issues and are in the process of drafting tables of organization options for the Commission, and discuss timelines for the application process and the investigation under the, we're now calling the Phase 1 process, RFA Phase 1. There are some new initiatives that we've also taken on this week. We're defining basically what needs to be covered in the memoranda of understanding. In some cases, there indeed may not need to be as many memoranda of understanding as we maybe originally had thought, which is a good thing, that procedures are in place, pre-existing procedures that can be utilized as the Commission begins its work. We have met with those various agencies with which the MOUs would be engaged, with the Attorney General's office, with State Police, and with ABC, Alcoholic Beverage Control Commission. We continue to work on a number of other matters. We are completing the application forms in general, both the multi-jurisdictional form, discussing whether that would be adopted in whole or in part and in what particular ways, and the Massachusetts supplement that would accompany that. It's fairly typical for jurisdictions to use those standard forms, but in every jurisdiction there are modifications based on the unique needs and the aspects of the legislation in that jurisdiction. We are finalizing our timeline. We'll discuss that a little bit further on the RFA 1, the Phase 1 process, when we expect the regulations can be considered by the Commission and can be promulgated for public consideration and then ultimately adopted. Our main thrust over the past week or so has been the drafting of the regulations themselves. And we are hopeful, as we'll discuss in the timeline, to get those to you very promptly. We are continuing to work with the Anderson and Krieger firm, the Massachusetts law firm, to integrate the Massachusetts peculiar, I shouldn't say peculiar, the Massachusetts specific aspects of procedure into the what are more generalized gaming standards. And we actually met with them about an hour ago. So we will continue to work on those areas and any others, obviously, that the Commission chooses to give to us. But we have our hands full, and we are very hopeful that we'll be able to meet the timing standards that I think Bob's going to discuss in a minute and go through the various timelines. Great. Is that
Timeline?
the timeline?
Okay, thank you.
So this is one of the memos, right, that you're
Right.
talking from?
June 18th, 2012.
Right.
As you know, there's,
Proposed RFA Phase 1 timeline, if it's in
Correct.
your packets. Okay.
we have been focused, as guys indicated, we focused our efforts on researching and preparing regulations that the Commission will need in order to commence and implement the request for applications process with a almost exclusive focus now on the Phase 1 aspects. That, as we've publicly announced, is one for the pre-qualification of potential applicants. As part of that, we have been asked by the Commission to produce a projected timeline consistent with what we know our experiences in the industry, and also trying to fill in the various nuances of Massachusetts law as it relates to regulation creation. In the memo that we've provided here, we've made certain assumptions and so forth, but we believe we've covered the various areas.
Excuse me one second. I see a perplexed look on one of the media's faces to just make sure we've we agreed that all of the memoranda that came from the consultant were ones we could give to the press. So if somebody can just make sure that Mark has, okay. Did you find it? All right. Okay. Now Dan needs to find it. Yeah, proposed RFA Phase 1 timeline. Sorry.
Okay, no problem. We have some flexibility built into this. Obviously, time is critically important to the process, and we've made substantial effort trying to maintain the responsibility to make sure that there's adequate time for input from all of the respective sources and persons and entities of interest, but also to allow for adequate review. As part of it, in the memorandum, you'll notice that it is our intention to get a set of draft regulations that are specific to the RFP Phase 1 process by July 10th. That may be pushed a day either way, but that is our intention. That would be essentially a set of working and operational regulations that would be needed for the Commission to move into the pipeline, so to speak, for both public consideration, local government consideration, and for the Commission itself in complying with its statutory requirements. As you note in the chart, there's different steps that are mandated by Massachusetts law in terms of notice and input, and they're self-explanatory. What we tried to do was pick, working backwards, adding the different time periods together, and then picking a time in the fall that if everything went perfect, which it rarely does, but giving ourselves a reasonable amount of time, but yet with our accelerator to the floor, so to speak, we looked at October, actually publishing the regulations in the register, provided all of the various inputs and processes have been followed. Working back from that and trying to meet all of the statutory and the legal requirements, we put together these different dates, and I could just highlight a couple of areas that I think would be important. Obviously, the commencement of the drafts, and by draft, what we've done is we've culled through some different jurisdictions in terms of regulations that are standardized to a certain degree in the industry, and then further refined them to comply with nuances of the Massachusetts statute. That draft will be obviously subject to a fair amount of change. It'll be, the core elements will all be there, but some of the nuances will await commission review and suggestions, and obviously the public, as well as Anderson & Krieger, the firm that's providing some legal input, and in fact, other agencies. As Guy mentioned before, we met today with the Attorney General's office and the state police and the ABCC, and they gave us some valuable input that will also be used in the preparation of these regulations. So our expectation is to be able to deliver to you a package of essentially practical operational regulations to be able to commence the process. As you'll notice in here, there is also a notice to the Local Government Advisory Committee. Again, there's projected dates in there. Then there would be a public hearing, obviously. Public notice and filing of responses and input and so forth, and then obviously contact with the Secretary of State. If all goes well and everything is agreed upon going forward and the Commission is satisfied with the regulations, then obviously there would be a publication, another opportunity for public hearing and a finalization for written comments. And then the Commission would have the opportunity for the final evaluation and for approval. Thereafter publication, which right now we're projecting roughly is October 12th, 2012. What would that mean? Okay, that would mean that at that point in time, we would have a set of basic fundamental regulations that we believe would be necessary, that should have been vetted by all of the affected agencies, would be compliant with the statute as we understand it, and would enable the Commission then to move towards the issuance of the request for applications. That is the objective, and frankly, that's what we've been concentrating on. Any questions on your guy?
I just want to, it might be important to underline also what these regulations will not include, as much as what they will. These are, as we've said, the phase one. And what phase one is, the regulations will cover generally are the, as opposed to the administrative aspects of the Commission's operation, and then the application process, the investigation process, and the hearing process.
This is phase one.
This is phase
one application.
Right, only applications on the integrity aspects and background of the applicants. It will not include anything regarding the evaluation of the project itself. Right. The entire project will not involve employee licensing, it will not involve vendor licensing, nor will it involve the operational controls that are necessary for the casino operation itself. Those will not be necessary at this stage, and so we're focusing on only that which would be required for the phase one vetting process.
Right. Do you anticipate, is there a window between October 12th, when the regs are published, and the release of the RFA? Is there any reason what those, what's the target?
Well, I guess the one variable might be the compacting process for July 31st, and then there's an October deadline in there also for that one region. But in terms of issuance, once the regulations are published, no, then then the Commission could announce.
Because we're working on the disclosure forms in parallel, right? So
correct.
Theoretically, mid-October is both the publication of the regs and, which the participants care about, the release of the
That's correct.
RFA.
The rules, that's correct.
Right.
Right.
All going well, that will be when the applications can be submitted.
Now, it looks to me like one of the major variables here is whether we submit the regs for review to the Local Government Advisory Council when they're still preliminary as opposed to final. And how does that decision get made? Can we do that? Is there an issue there, or how does that decision get made?
Well, Anderson & Krieger has advised us, they are advising us in the process of the regulation approval process. I believe that's something that we'll probably have to wait until we get the final draft of the regulations together to submit to you all. If it would seem that the commission could make that decision, but there are certain requirements in terms of the notice. Off the top of my head, I don't recall specifically whether they would have to go out in draft form, but I know there was discussion that there would be input sought from the local governments at the earliest possible stage.
Right.
If that is in draft, it would certainly be before the, before you make any final decisions or anything like that.
Yes, I understand what Anderson and Krieger have told us is that there are two options. We don't have to do that in order to continue the process. But if we don't do that, then we have to later give them the regulations and the opportunity to review
Right.
them, in which case we
Right.
might be delayed at that point. So to give them the draft initially may expedite the process.
I had a
If I could just
question.
pick up on what Guy said. The real difference is, when we get these regulations on the 10th, the schedule has built into it about a 2-week process, a little bit more, 3 weeks, for us to review them. And before, and this is just in their draft form, this isn't the public hearing, this isn't any of it. It's for us to review them and decide that they're not final necessarily, because we have to go through the process of public hearings and the like. But we're satisfied now that the draft is complete enough, it's got enough finality to it that we're prepared to go forward and put these out for public comment. And the first step in putting them out for public comment is sending them to the Local Government Advisory Committee. We have an option, and that's what these two boxes on the bottom of page 1 indicate. We have an option to send them to the Local Government Advisory Committee before we're finished the process of our own internal vetting and thinking, or waiting until we're finished, until we finish doing that. That's entirely up to us. And it doesn't change the overall timelines at all. It simply gives, if we submit preliminary drafts to the Local Government Advisory Committee, it gives them a little bit longer time to work on them. But they still have 3 weeks, I believe, to work on them in any event. And
Oh, okay.
I
So
have
I
a
misunderstood
view
this.
as to, when the time comes, as to what we ought to do on that one. But
The process will be dynamic also. I mean,
Right.
there's going to be exchanges and so forth
Right.
that'll require adjustments.
But either way, I thought this was a mistake. Either option still gets us to October 12th.
Yes.
Exactly.
Okay, I'm
Yes.
sorry, I
Exactly.
misunderstood,
Yes.
okay. And I guess you're overseeing it's contingent upon efficient review and editing process, which I guess means us, which probably means Commissioner McHugh. Are you
Well,
the
it
principal?
means I'll act as a gateway and tee these things up, but it means that we all have to be involved in the process, and I'll help lay out a plan to do that. But yes, it gives us about 3 weeks to take the handiwork of our consultants, look at it, understand it, have some dialogue with them, and then get it ready for the LGAC by the Local Government Advisory Committee by, in my view, the 31st of July.
Got it, okay, good, I misunderstood, thank you. All right.
Okay. You want to do next?
What's next?
One of the other areas that we covered on the memoranda was the revenue sources, if you want to do that one at this point?
Yeah.
You had asked us to identify those sources.
Before we start that for
Okay.
a second, could I just talk about two other aspects of this? The other part of this that is important to keep in mind, the other variable, is when we have the public hearing. In order to meet the final deadline, we have to have it no later than September 7th. We can have it earlier, depending on the other timelines, but that's the next big deadline that we have to face. So the first deadline is July 31st to get it no later than that to the Local Government Advisory Committee, and then the month of August, we'll still have some time to work through it, but we have to have the public hearing. That's really the opportunity for the public to make their final comments, their final input. We'll solicit that in a variety of ways and have a formal hearing, and that's got to be done on that day to keep this this process moving forward. So that's the next key date we have to keep in mind.
And as I understand it, one of the triggers of that is you have to hit the publication dates of the register, so that, you know,
That's
if
right.
you miss one, you're delayed 2 weeks.
Right, so you miss it by a few days and you can be delayed a couple of weeks. So that's why that date is so critical. Okay, sorry.
Great, thank you.
Okay, revenue source, as I said, you had asked us to identify the sources of revenue for both the commission and other related areas that the act contemplates. And we provided you with a chart that identifies those very summarily. It's kind of self-explanatory, but I'll just review it as an overview. Section 94 of the Act is the one that provides the Commission with its startup finances. It comes out of the Commonwealth Stabilization Fund, and it is $15 million. $20 million ultimately has to be paid back to the Community Stabilization Fund because there was another $5 million that was devoted to the Attorney General's office, and so when the Commission receives sufficient funding.
The governor's office. Governor's office.
The governor's office. When the Commission receives sufficient funding, that money is to be returned. The Commission then gets its continuing operations funding from a series of fees. One, the initial application fee, which for each applicant for a casino license is $400,000. Then slot machine fees, which is $600 a machine. Then the fees that are assessed for the investigations into violations, which is specific language of the Act. It is not fees that are assessed for the investigations of the backgrounds of the applicant. It appears to be only the fees that are assessed for violation investigations, and those won't be until operations begin, quite a ways down the road. Employee license fees are another source of your revenue, and vendor license fees. So now, if those combinations of funds don't pay for your entire operation, then you are authorized to assess the casino licensees for whatever is not compensated. With regard to the Gaming Revenue Fund, which is a fund that is devoted to a whole series of different separate funds, which are delineated here in the chart, but I don't think need to be recited today. The Category 1 and 2 renewal fees go into that fund, and the tax on casino gross revenues goes into that fund. That's going to be the major source of the revenue there. All penalties for violations will go into that fund. Prizes, jackpots that are won by individuals in the casino that are not claimed for more than a year will then escheat to that fund. And any prizes won by minors that you identify and catch will
Prizes
be
won
repaid.
by commissioners.
Right, well, by commissioners, that may cause more problems. So that's the source of the Gaming Revenue Fund, and as I say, that gets divided up among, well, Category 2, the revenue tax is 40%, Category 1, the revenue tax is 25%. So all those, as I said, those taxes go into the variety of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 different other funds at various percentages that are defined by the statute. There is also a gaming licensing fund. Into this fund go all Category 1 and 2 licensing fees except the initial application fees. So the initial $400,000 initial appliation fees go directly to the commission, the Gaming Control Fund. The other fees, which are the large amounts, the 80 million and 40 million, I guess, they go into the Gaming Licensing Fund, and again, divided up in various percentages to 1, 2, 3, 4, 5, 6, 7, 8, 9 other funds. The Gaming Licensing Fund expires on December 31st, 2015, and so presumably, and we could talk later on, that would not pose any kind of, we would have to deal with that end date in other ways if it becomes an issue. But at this point, those are the funds, that's the revenue that you would receive. There are also, with regard to racing, a racing development oversight fund that goes to fund racing operations, and we've identified the series of sources of revenue for that fund. Most of it license fees, portions of daily pari-mutuel wagers, unclaimed winnings, again, annual assessments, portions of the horse racing simulcast wagers, and portions of the greyhound racing simulcast wagers. An additional racehorse development fund is created by the statute, and that fund will distribute the monies to each licensee per the recommendation of the Horse Racing Committee, and that is funded by a percentage of wagers on simulcasting. There is a local aid fund to support municipalities where the racetracks are located. Percentages from pari-mutuel wagers at each racetrack go into that fund. There is a running horse capital improvement and promotional trust fund that support tracks for capital improvements and marketing efforts at the tracks. A percentage of simulcast wagers go into fund that particular purpose. There's a harness horse capital improvement and promotional trust fund that supports harness horse racing and capital improvements at those tracks. And again, a percentage of the simulcast wagers will be devoted to that. And finally, a racing stabilization fund that will intended to ease the impact on the ban on live dog racing, and a percentage of simulcast wagers will go into that fund as well. So there are any number, well, there's not any number, there's some number of funds that have to be accounted for, and the commission is charged with the regulatory authority to make sure that all the appropriate and proper accounting for those is done and distributed, and enough is retained for your own operations. So if there are any questions about that, that's the revenue.
Does anyone know there's the $5 million annual appropriation that we talked about, Commissioner Stebbins and I, that goes to the Public Health Trust Fund?
Yeah.
That's in addition to this, apparently?
Yes, I think that is.
Okay. So the Public Health Trust Fund gets 5% from the Gaming Revenue Fund and $5 million. Okay.
Right.
There is a phrase that's used sometimes in looking at the economics of the gaming industry that talks about the effective tax rate. You've got the formal tax rate, which for us is 25% and 40 or 49%. But the effective tax rate, I assume, calculates in some formula or other the capital, the initial one-time license fee, other things like this appropriation for the Public Health Trust Fund, et cetera. Is there a formula that can tell us what the effective tax rate of this legislation is?
It's something we could look into. We couldn't tell you right now, but
You know what I'm talking about,
yes,
though.
yes.
Because I've seen it referred to in a number of documents, and
Yeah.
we're going to. I mean, the industry is going to be looking at this. The 25% is fine. Sounds kind of a little on the low side, but there's all these other things. What is the effective rate? And that'd be something helpful to understand if we were looking at it through the same prism that the industry would use.
Okay.
Do you usually find those combined with any local assessments that a licensee is requested or required to pay?
Are these, you mean the effective tax rate?
Yeah.
Yes, it would probably be.
Would count that too?
Yeah,
Yeah.
sure.
So
Would that?
that would include property taxes then?
I don't know if it would just include property taxes,
No,
but property taxes, any mitigation agreements they
Right.
have with the host
Right.
community, et cetera.
Just a question for our guidance in researching this. Would there be one standard that would apply to all, or wouldn't that effective tax rate depend on the nature of the investment and the size of
Yeah.
the development and their
That was going to be my point. There's a denominator piece in here, which is just that, the capital investment. So the upfront fee plus however many percentage taxes on revenues really has to be evaluated respective to the capital investment. And because we only have floors right now, we don't have however many dollars operators will invest. It's only a proxy for the minimum.
How does,
Can you,
So $500 million is the minimum investment for a type 1.
Right.
If we are, like we are required to assess a fee of $85 million, which is the licensing fee, $400,000 application fee, and 25% on their operations, you bundle a lot on the revenues, you bundle all of that together, divide by the minimum capital investment, and you get an effective tax rate, 27 or 28, however, but it depends on the size of the investment. Do you see what I
why does
mean?
it depend on the size of the investment as opposed to the size of the investment plus the revenues? The percentage figure is a percentage of revenues.
Right.
So how can you
Well,
calculate an effective
actually,
tax rate?
perhaps
until
what
you
we,
know
what we really mean is the size of the revenues, the size of the operations. Whatever those operations in whole dollars are gonna kick in. We know that the state gets 25%, but what about the 85 million? What do we divide that
Yeah.
into?
I understand that, but my question is, can you calculate an effective tax rate until you know what the revenues are in addition to the capital investment?
Well, I guess there's an assumption that that there's a correlation between the revenue sizes and the capital investment, and that's the proxy.
An assumed,
There is an assumed.
There's projections.
It's
You can
projections.
do it based on projections, that's the only way you can do it.
I had a question.
excuse me, but
Does that-
is that,
no?
are you, do you?
I think there'd be variables. I suppose that we could come, someone we could work with could come up with an approximate
Yeah, I think
effective
that's
tax
what would
rate,
be an
but it
approximate.
would have to be approximate. I don't, because you say, even if it's a projection of potential revenue, it would depend on the size of the project, and we don't know what size projects people are proposing.
I don't understand why it's you're 85 million, you have to figure out what to divide, you'd probably divide your 85 million by 15, because it's a 15-year license. So you're 85, that would be, whatever that turns into, 85 divided by 15 is what, 6 or something? So
project the-
6 million a year.
Okay.
So your effective tax rate is 25% plus 6 million a year. That you can't convert to a percent until you know revenues. Right. Right. So you could say at revenue level X, your tax rate is Y. Okay.
But even that would vary, because your 500 million is a floor for your capital investment. You may end up with a $750 million investment, depending
But I
on
don't
the
think your
size of the
capital
scope.
investment has anything to do with the effective tax rate.
Well, it would be
Well-
divided by, if you're breaking it down on an annual basis in terms of your total investment. If the applicant is looking at it and saying, what is this gonna cost me for the period of operation of 15 years, okay? My capital investment is relevant to that.
Well, that's looking at your return on investment, but not your tax rate. But anyway, we can, just long as if you
Yeah,
can
well,
give us some kind of a
understand.
tool to,
Right.
maybe what it is just a tool that we can adapt as proposals are coming in. But I think it'd be something useful. We have this issue of this possible annual assessment to cover excess expenses. It's
Right.
an open issue. We don't know what that is. We don't know if it's anything. But I think we need to understand a little bit where in the continuum of tax rates we are sort of against the industry standards. And I don't quite know how to convert that yet. Okay, anything else on?
Yeah, I just had one question about, many of these monies are coming in at later dates,
Right.
after operations begin and whatnot. I know you're not accountants, but.
Correct.
Did you have a chance to look at the monies coming in and assess if there will be enough? Is there a cash flow issue? Do you anticipate having an annual assessment to cover expenses?
There will likely be an assessment, but we couldn't really give you an estimate on that until we knew what the commission's budget is. We haven't really gotten to the point of establishing what the commission's actual budget will be to know enough to give you an opinion today about whether the extent of an assessment or whether or not an assessment's going to be necessary.
And that'll really depend on how many people we hire and what time
Right,
frame
right.
we hire them.
Right.
Okay, thanks.
Just on that point, I'm working on a draft budget as we speak, and hope to get something order of magnitude very, very soon for the next fiscal year. And of course, the moving pieces relative to the higher even additional space for the commission is a variable there, and we'll just have to make some assumptions. But that's also in the works from our perspective.
Anything else on the revenues?
No, thank you.
Okay.
You want to do next?
Scope, I'll do the scope. The other, one of the other areas that you asked us to kind of discuss is what we colloquially call the scope of licensing. What this means is, it's one thing to say that an applicant has to file for investigation and review, but the meat of that is to determine who is the applicant. And in kind of gaming parlance, that's called the identification of the qualifiers. A casino company is evaluated on the basis of the people and entities that give that company its direction and control. So in a variety of aspects, the commission will be required to determine who and what are those people who are giving this particular applicant company its direction and control. You will not get that would be unique if you received an application from just one company that had just one set of ownership and a couple of people running it. Typically, you get a subsidiary of an intermediary company that is in turn owned by another intermediary company that is in turn owned by a holding company that can go on into a flowering tree. So the evaluation that the commission has to make is in how far up the tree you want to climb. And those are not necessarily they're objective, but they're not necessarily standardized kinds of determinations that can be made. You have to evaluate each table of organization as it comes in on its own merits and determine who among those varieties of people and organizations are the ones you really want to focus on in evaluating the integrity of the operation that's being proposed before you. There are generalized standards that are used throughout the industry. And the regulations that we are drafting and the ones we will propose to you will include those generalized standards. Typically, it's the officers, directors, and controlling shareholders of the applicant company, its intermediary and holding companies. Those are not all that difficult to determine and evaluate. There are nuanced questions about some directors, if they're outside directors of a remote holding company, whether or not you want to include them. But for the most part, you can make some fairly clear delineations and decisions with regard to those. The application form will request all of those people. And at some point, either if the applicant wants not to have to file on some of those people, they will request conferences or file a petition with you and seek to either have a waiver executed so that avoids that person from filing, or informally discuss it and have either the deputy director or the executive director or ultimately the commission make a determination on whether or not someone is in sufficient control and in a sufficient position of influence that they need to be someone that you need to look at. The problems arise most often in areas of shareholders and investors. The financing of the entity can be very complex with a variety of mortgage holders and institutional investors and other forms of investing mechanisms. And the documents that form the basis of those loans or equity investments need to be evaluated to determine if, in fact, they provide enough control on the part of the investors to warrant their being investigated. A lot of the investors that you'll find, we think, if it's typical of other jurisdictions, are used to this. And they provide in their documentation some phrases that avoid their needing to be qualified. There are kind of standard lock phrases in these documents that can be used to put a kind of a dividing wall between the investor and the operation of the casino itself that will allow gaming agencies to make subject or their own discretionary determination on whether or not it's necessary to look into all of these investors. The standards for that we will provide in the rules and the regulations. There will not be specific standards because, again, the decisions are made on a case-by-case basis. But as I say, the regulations, when we propose them, we can talk about this in more detail. But the generalized format for it will be that the application will submit all of this information, and then the applicant will either seek or not seek to have certain people excluded from the process. A question has arisen in the course of our discussions about whether or not we can proceed, or you can proceed with the investigation while we're still evaluating whether or not everyone who should have filed has filed. There are different ways to look at this, and it will be ultimately up to you. But it is common that the investigation does proceed on those people that it is clear are qualifiers. And if there are people who we're debating over whether or not their filing is necessary, their backgrounds will just have to await that final determination. But it would slow down the process probably unnecessarily if we waited until every issue was decided about the global necessity for all of the applications to be in before we started anybody. So that's essentially the scope of licensing as we contemplate it, and we'll put more meat on that, obviously, in the regulations themselves.
On the point that you made last there, I think it would be helpful as you draft the regulations to know the Commission's position on that. And the question is, as the memo suggests, whether if there's a question about some qualifiers, some potential qualifiers somewhere in that flowering tree that was discussed, whether you wait and resolve the question, whether the Commission waits and resolves whether that qualifier has to file the information that's required before any qualifiers can be investigated, or whether if there's a dispute over the necessity for one or more people to file, the application can be filed, and the investigation can go forward with respect to the people who have filed their disclosures and as to whom there's no doubt. And it seems to me, as was suggested, that allowing the process to move forward would be helpful, and have those the need for the other people to file an application or disclosures await the outcome of our deliberations, but not delay the overall progress of the investigation. So I think if we're of like mind, that would be a helpful thing to tell our consultants as they so that the regulations can be drafted with that procedure in mind.
I would agree with that notion that starting the process of evaluation of those qualifiers who are clearly so would be helpful because there will be a resource or capacity constraint in the ability of this commission to really perform all of those investigations or commission them or contract with a third party, or maybe it's all of the above. But I would agree with the notion of this starting the process while some other qualifiers may show up later on.
I would agree with that.
Me too.
Makes sense.
Yeah.
It's common practice.
Okay.
Yeah.
What was I going to say about that? I lost my train of thought, but I went, something else came up as you were talking about this that was a question I meant to ask, and I know it's in everybody's mind somewhere, but it's not noted on here, and we just don't want to lose track of it. We are mandated to put out the RFA for the slots parlor before we put out an RFA for the, so, you know, whether that's an hour or a day or a week or how we factor that into this schedule, we just need to make sure we haven't, don't lose track of that in there somewhere.
And that your direction, the timing would be as you
Do we have, does it mean just in moment in time, or does it mean a week, or does it, I mean, can we?
At this stage, we're looking for the qualifications, and we're not looking for the final application. And it seems to me that we've got more flexibility at this stage than we do when we get to the substantive application stage, so.
But, sorry, go ahead.
So I think we can satisfy the statute by, my thought is we could satisfy the statute by asking for all the qualifiers at the same time, because we're not going to make a final decision on anybody's project until after the qualifiers have been determined. But then we have to deal with the slots parlor final application first.
I thought that in the statute, there's only one application.
Right.
There's only, we've broken that one application into two phases. I thought we were construing that when they file the application for phase one, they file the application, period. That's the end of it.
Yeah, correct.
So if the slots parlor has to file that first by some amount of time.
Well,
And then when we make decisions is no longer mandated in the legislation.
Yeah. I don't think we've made a formal decision as to that. I mean, that's certainly a reasonable way to interpret the statute, but I don't think we've formally discussed that and come to a conclusion that that's so.
Okay, and you think that might be debatable?
I think it might be debatable.
Under that assumption, that the start of the application is the start of our phase one, looks to me that the constraint would be that publishing date of the Central Register, that September 5th. Unless it was at the same time, and we interpreted that because they were both let out at the same time, the slots parlor it complied with the legislation.
The September 7 date doesn't really have anything to do with that. The September 7 date is the date for publishing, having the public hearing on the regulations. We get all the way to the end of the regulations, we promulgate the regulations, we publish the final regulations in the register, and they become effective. Then, at some point thereafter, we issue the RFA 1. And we can stagger the issuance of the RFA 1 at that point, or we can, if we conclude that it's the right thing to do on the first stage, just promulgate one RFA 1. We have some time to think that through and figure that out. It doesn't affect the way we approach the regulations and the regulation publishing process, but it's something that we need to think through as to whether we.
It's right, so it's pretty significant, and I think we should.
Right.
Do you want to?
That's correct, only, just to reinforce that, the way we're now preparing the regulations, subject to your review, does not distinguish between the Category 1 and Category 2 application process. They're the same. They're the same standards, the same process, so it wouldn't be, we would be promulgating the Category 1 and then the Category 2.
Which the legislation,
same rules.
the legislation seems to have the same assumption,
exactly.
right? So really, the only question is whether this is the date that's called for to be earlier or not. If the issuance of this RFA is the RFA in which we have to meet the requirement to issue slots first.
Yes, that's right, and that decision point becomes relevant after we have the regulations in place, under this schedule, October 12, and then we decide when the RFAs get issued.
Right.
We decide it beforehand, but then we execute that decision after October 12.
Right. Okay. Are there circumstances where you have the same entity that one jurisdiction licenses and another jurisdiction doesn't?
Absolutely, yes.
So the multi-jurisdiction form
Right.
is interpreted in different ways in different jurisdictions.
Yeah.
Like, what's an example of a known company, a big company that on the same set of facts can operate in one jurisdiction but not in another?
MGM was denied a license in New Jersey. Well, they withdrew, but they were objected to in New Jersey. Caesars, they were denied, but their owners left the company so that they could retain their license in New Jersey while they were operating in Nevada and other places.
And MGM, at more or less the same time, was permitted to operate in other places?
Everywhere else.
Oh, interesting.
And that was based on their business practices in China?
That's
Is that-
in Macau.
Yes.
Right.
Okay, interesting. All right, thank you.
Okay, I think there's one more.
One more. The statutory staffing. The executive director position, we had sent a memo to you.
And executive director salaries.
Salaries, rather,
Right.
yeah, there's two of them. We had done an examination of some other jurisdictions that have, comparable in terms of commission, potential size and so forth, responsibility, and also commissions that employ full-time executive directors who bear a great deal of responsibility. Certainly, the jurisdictions differ, first in what their commissions are required to do and are tasked to do, and then in turn, the responsibilities of the executive director varies considerably among jurisdictions. Just looking at the comparative salaries we put forward here, it's the recommendation of the consultants that due to the broad responsibility that this commission has, and likewise the broad responsibility that the executive director would have, both under the statute and as a practical matter as the administrative head on a day-to-day basis, that it was our recommendation that the salary be set at the upper level or near the upper level of the comparatives. There was also an issue, a statutory issue that we wish to address just in terms of the reporting function. The statute right now directs that there be created within the commission an Investigation and Enforcement Bureau, which is a position of a subset of the commission that is extremely important. This is the group that will be doing your investigations, will be responsible for much of the sensitive work that you'll be doing, although most of the work of the commission is deemed sensitive. But this particular bureau, under the statute, is to be headed by a deputy director. In turn, the statute also calls for the creation of the executive director position. The statute, however, has an anomaly in it, and we express no opinion on good or bad, but just simply to point out that the current chain of command for the deputy director of the IEB goes directly to the chair. The executive director, obviously, in the structure that's been contemplated, would be the person that would be, say, the highest-ranking non-commissioner officer in the commission, both for administrative purposes and the practical aspects of having a person with that degree of responsibility also having knowledge of the operations of one of the most critical elements of the commission, would suggest that there should be a line of authority between the IEB deputy director and the executive director. This will obviously be a commission decision going forward. We pointed it out to you all, in terms of how we drafted in the RFA P1 regulations. We are obviously addressing some additional criteria that the IEB will need, because that will be the point agency that you will be referring the applications to for review. And this particular reporting structure and the relationship between the deputy director and the executive director is something that we believe would be in the best interest of the commission to address at this early stage. Likewise, in terms of the reporting, we met today with the Attorney General's office and the state police and the ABCC, just in terms of the interaction, the statutory interaction that's set forth regarding the IEB, the deputy director in charge of the IEB, and those other agencies, both for referral of, for example, if criminal activity is disclosed or discovered, the Attorney General will be assembling its casino prosecution unit. We expect that there'll be a good deal of interaction between the deputy director of the IEB and that unit of the Attorney General's office, and obviously the state police will be providing staff both to the IEB for backgrounds and investigative personnel for the Attorney General's casino prosecution unit. All of that being said, the executive director, who will be a person that you will rely on heavily to keep you informed of the activities of the commission and for you to transmit directives and so forth. It would seem to us logical and prudent to include the executive director in that chain of command. And our preliminary discussions, both with our legal advisor and among ourselves, the various consultants, was that that could be done by delegation of the authority of the chair if the commission decides to do it that way. I think
We're
that's-
while we're on that, I'll get to a few things. I think
Okay.
the issue about the statute takes the one deputy director who's in charge of investigations and enforcement and has that deputy director report directly to the chair rather than to the executive director. And just for the public, there are interesting issues involved in that, and we have begun to think about it. But if anybody out there has any comment on the issue, we'd be interested in hearing it. I meant to ask you this in this chart, when does the IEB does the investigations. We can't do the IED may delegate the investigations. We haven't figured all that out yet. But when does the IEB need to be started in order that we have the entity that can do the investigation? Where in this flow chart does that occur?
Well, if we anticipate the the request for applications to go out in October, and then
By October.
have so many, say 60 to 90 days for applications to come in, it certainly needs to be staffed up by the beginning of the year so that there will be at least sufficient staff to be able to handle, if they're not handling it themselves, to be able to oversee any other third parties that are doing it on their behalf.
Right,
I
okay.
mean, it would be recommended at this point. I think that you would consider, an aggressive effort to get the deputy director, who is an important person in this and needs a broad range of both investigative and regulatory experience. But that person in place would be supervising, at least for the preliminary RFP1 phase, RFA-P1 phase, probably an amalgam of some state police personnel, and perhaps if you conclude to bring in some third-party experienced investigators, who for that initial period of time would be provided the files for the investigative review and report back through that deputy director.
Right.
Now, if that position's not filled, certainly someone could be designated in the interim to head the unit.
Right.
But that unit should be in place, at least structurally, and able to receive applications as soon as you decide to publish the request for applications.
Right, okay.
Quick question with respect to some of the salaries. Obviously, the states give them different responsibilities, and you recommend the high end of the salary scale, but how much of the salary scale, at least for the 4 jurisdictions you looked at, were based on the experience of the individual in each of those slots?
Probably a great deal. You have a lot of persons that are holding those positions now that have held important administrative positions for years.
Okay.
Some have been homegrown that have progressed through agencies and so forth, but some have moved from agency to agency. I would say that the justification for that level of salary is primarily driven by the experience doing exactly this function.
Okay.
And the range of duties that they would have. I mean, again, your commission statutorily is given a broad responsibility. We would think that that executive director in this particular commission is going to have a lot to do and would certainly justify that. And I would think of the commissions that were referenced here, might be more than all of them, really. I would think, pretty close.
It probably is. Not all the executive director positions have the same responsibilities. In New Jersey, for example, the executive director of the Casino Control Commission is a purely administrative position. They have a separate agency does all the investigations. So it's a combination, as Bob says, of the experience of the person and the role that the person is going to be playing. Here, the role is substantial.
Could you just, sorry, go ahead.
No, 'cause I mean, we know Pennsylvania has multiple facilities. I mean, they're up to 13 casinos that they've licensed. Ohio is less than that, probably more measurable with our scale, but the response, those were the 2 jurisdictions that interested me the most in terms of the responsibilities for those 2 slots, as well as how much of the salary was dependent on their years of experience.
Pennsylvania also has a administrative, fairly clear delineation between the investigative bureau that they have, the BIE, they call it, transposed from yours, but their bureau is intended to be more independent of the commission operation. The executive director doesn't get involved as much in the investigative aspects of things in Pennsylvania, although he certainly has administrative jurisdiction over it. There is a director of the BIE there who is would be similar to the deputy director of IBE here, and they treat it as a little bit more delineated.
So what is the difference here? What is it that the Pennsylvania executive director does that the Nevada and New Jersey folks don't?
Well, the New Jersey one is just that he has no role in investigation at all.
Okay.
He's just
So the whole
administrating.
BIE piece is not there.
Right.
Right.
What about compulsive gambling? Is that-
He would have a
Okay.
role in that, but not in a policy-making position. They would be, again, purely administrative. The executive director is somebody who handles the human resources and, internal financial operations of the agency. This is in New Jersey, not a substantive policy-making position.
Actually, what you have listed here is the Director of Division of Gaming Enforcement.
Well, that's
Director of
yeah.
Division of Gaming, rather than,
Okay, then the executive director of the commission.
Yes,
Well,
two
okay, we're
separate
talking about executive. The director
agencies.
of the Division of Gaming Enforcement, we list it as being more comparable to the executive director here, although probably even more responsible than, in some ways, the Division of Gaming Enforcement, because you have one agency as opposed to two, and your executive director is going to be both administering the agency, the singular agency, and being in charge of the investigation. The Director of Division of Gaming Enforcement has no role in the Casino Control Commission. So you have one agency, and your executive director is over the entire operation.
so this will be the most powerful commission. It's from your research.
Yes.
Oh, yeah.
Yes.
And that does not even include the racing function, which is another
Good
piece.
point.
And
Good
lottery.
point. Good point.
Well, no, not the lottery.
No, not the lottery.
No, not
That's
the lottery,
right, that's
but
right.
certainly the racing. I don't know that there's another state that has combined the racing
Racing, no.
piece into the gaming commission.
No.
I think so.
Okay.
I think whether it's done by the search firm or you all, maybe it should be the search firm, but we need this laid out much more clearly. Because if we're gonna, if the right salary is 30 to 40 to 50,000 more than most of what might think would be comparable, we're gonna need to be able to justify that really clearly. I don't-
Functions and
Yeah,
compare
like-
functions and so forth, okay.
Right, because anyway, yeah, because this discussion that we've had has begun to shed some light on that, but I couldn't get it from the memo.
Fine.
Okay.
We would, that.
Just it
No
does have to
problem.
be a written, just almost a matrix,
Sure.
Yeah.
that would
What are their
make the difference.
responsibilities as compared to
Right.
this?
Right.
Are any of these salaries set by statute, or are they all individually negotiated?
I don't think the.
Ohio.
Ohio sets it.
Ohio is, okay, then you're correct. Ohio would be the only one I don't know, I don't think
That'd be
Pennsylvania
a
or
helpful
New
thing
Jersey
to
are.
know, too,
Yeah.
as part of the matrix, as to whether the
I have a question relative to the deputy director of IEP and whether, because I think you mentioned in the memo that there may have been a legislative intent to keep the functions separate, to emulate perhaps other jurisdictions where there are two separate agencies. Could you speak a little bit more to that effect, or whether we have done some, or will be doing some research relative to the legislative intent, or?
Sure. There are a number of different, Nevada, for example, has two agencies, New Jersey has two agencies, and the idea originally, certainly I could speak most to New Jersey, but also Nevada, is to make sure that there is an independence of the investigative function. That the decision maker over a license not be the same as the person who is looking into the background of the applicant. In New Jersey, candidly, that didn't work. The legislative scheme was such that there was a substantial and significant overlap as between the two agencies, and everything became duplicated, and it was very inefficient. And they have actually folded the decision-making process into the investigative agency now, so that the Division of Gaming Enforcement essentially does everything. Casino Control Commission only decides on casino licenses, doesn't decide virtually anything else. Nevada has been able to work out their system by keeping the commission at a very small level. They have very minimal staff. They have commissioners, and the bulk of the work is done by the Nevada Gaming Control Board, which itself makes decisions, and those decisions then go to the commission, and to overrule the Gaming Control Board, it takes a unanimous vote of the commission. So everybody has their own kind of system. But most jurisdictions handle it the way here Massachusetts has, that there's there's a one singular body. It avoids that overlap and that potential for duplication. But within the structure, there are mechanisms to ensure that there isn't too much of a disturbance of the investigative process by those who may ultimately be deciding the license. And that's not hard to implement. You may have we'll be talking about that. We have that in our regulations, that whether you have a legal division that has hearing officers that will be making the recommendation to the full commission, whether you have commissioners, these are all options that will be in the regulations. Whether you have usually administrative law judges, the investigative body will not be the part of the commission that will be ultimately making the decision about what the investigation has turned up. They'll be presenting it to some format that the commission decides will be the necessary format for an objective decision to be made. So, and that satisfies due process. Would not be any kind of a due process issue. The legislation implies that here, that the IEB has its own deputy director, and it conducts its investigation, and then it makes a recommendation to the commission. But the commission is not the investigator. The commission has an administrative role over the IEB, but it's not directing the investigation. The IEB conducts the investigation.
Okay. I mean, semantics-wise, it just seems that I just found it curious. You have a deputy director. So who's their director if they report directly to the commission anyway? So.
Right. Mm-hmm. It's a conundrum. I mean, you can see there are some subtleties in this issue, and I think that you can see what the legislature was getting at, because it looks like every other regulatory unit or every structure across the country is wrestling with this same issue.
Yeah.
But it sounds like your sense of best practice is not to worry about that, is to consolidate the administration and management of IEB under the whole administrative structure, and just reserve to the commission the adjudicatory, if you will.
Right.
Yeah.
Right.
I mean, there's some jurisdictions that have no distinction whatsoever, which has passed due process muster. So to have even this distinction that you have in this act separates you from other agencies that are less divided.
Right. Okay, well, we'll keep thinking about this. I'm not sure how much, there was also the memo about the mandated positions, the June 15th statutory staffing positions, but I'm not sure that there's really anything to talk about other than the issue that you've already raised.
The executive director appoints or chooses to the chief financial and accounting officer, and then the legal.
But all these determinations are subject to the approval of the gaming.
Of the commission, correct.
Yes.
The timing, Mr. Chairman, of the need for the head of the IEB gets back to the discussion in a way that we had last week about once we get the executive search underway, the desirability of beginning on a preliminary fashion, at least to look for the other positions so that the vetting can take place and then be teed up for the executive director once he or she comes aboard.
Yeah, that's a good point. And we're talking, one or two of us are talking with one of the consultants, John Bowman, I think, tomorrow about different organizational structures, and as that starts to take shape, then we can also, you've given us recommendations about what you think the priority hires are. And I think within the next 2-3 weeks, we ought to start doing that, so that's
I
good.
mean, you would actually be tooling up your investigative component, probably, and presuming the current timeline would stay intact. September, October, identifying the persons that would be involved in the investigations and then having your reporting structure in place so that when that RFA goes out, you're ready to go, and as the information comes in, it's gonna take some time to submit, but should be some pretty good turnarounds too, so you'll be ready to at least get the thing rolling and downhill.
I have one last question. The 4 commissions or jurisdictions that you referenced in the memo relative to salaries, are all those commissions full-time commissions?
Yes, yes.
Well, there's only one, which is New Jersey, that you only reference one commission. You're just, there's only.
Well, commission function and those persons are all full-time positions.
No, I meant the commission.
Yeah, yes.
Not the executive directors, but the commissions.
Oh,
No.
No,
No.
they're not.
They're
Only
not.
New Jersey.
Only New Jersey has a
Yeah, no, they're
full-time
not.
commission.
Okay,
Pennsylvania's full-time.
anything else for,
Oh, I'm sorry, I was just disagreeing with my partner on something.
I think we're good, if you are.
I would just say for the record and for the public, our consultant team, Michael and Carol and Spectrum, and our law firms, Anderson and Krieger, have been great. And you guys, you've been helpful, you've been fast. I think we're 12 weeks into this, and we're starting to generate a lot of stuff, and a lot of it has to do with you, and we appreciate.
Thank you
Probably
very
your,
much. Thank you for the
your biggest,
opportunity.
your biggest mistake was agreeing to have a former police commissioner be the project manager. But it's working, so we really appreciate it, and you're doing great work, thank you.
Thank you.
I'm reminded of that about midnight when I get her emails.
Yeah, right. Right. Thanks very much.
Thank you.
Okay. 5C is the issue of technical and other assistance to communities. And there are, let me think a second now, where are we here? Yeah, we have two things here, right? We have okay, so I'm sorry, we've got two different items, okay. One of them, the first one is, we talked after our community mitigation meeting, open meeting 2 weeks ago, we talked about having some kind of an advisory opinion go out to communities that begins to suggest a time frame that they can use to deal with developers saying to them, we gotta go, we gotta go, we gotta go. And to tell them in some constructive way what kind of help will be coming from the commission and how. And to get the conversation going based on what I've known and what we've all talked about, I did this draft. But it's completely a draft, and I want to make absolutely sure anybody who sees it, that the timeline is extremely in the draft. I do think it's important that we figure out how to convey to the cities and towns that you don't need to be desperately under the gun. If you don't feel like you're ready to negotiate a host or surrounding community, you don't have to. There is time to do that. It's perfectly reasonable for a developer to want to get moving, but it's also perfectly reasonable for a city or a town or a community to say, we're not ready yet, we need some help. So that's one critical point I think we need to get out there, because I don't think municipalities have a realistic sense of what the timeframes are. But the timeframes are purely broad brush to give them that sense, and nothing that anybody in the audience or any reporter or anybody should construe as any kind of a formal decision-making or even aspirational schedule. It's just a gross, rough estimate to give particularly municipalities a sense of what's going on. So having said that, what I essentially did, if you turn to page 2 of this memo where I put the schedule on the chart, I put all of the steps as basically 3 to 6 month steps. And if everything took the shortest possible time, if each step was a 3-month step, we'd be done by October 2013. If everything took 6 months, we would be done by November 2014. And no doubt it'll be some combination thereof. But I think it would give cities and towns, you know, a little bit of a planning sense. And I tried to explain where the execution of surrounding and host agreements would fall, which is mid-next year at the very earliest, would be required, I should say. So that's what I was thinking about this. I would like to get something that we are comfortable with, ready to go out to prospective host and surrounding communities as soon as we can. But I'm completely open to edits, changes, whatever.
I read this and had one thought on behalf of the surrounding communities, because those that are prospective host communities know whether they are a host community or not, but the question about whether somebody is a surrounding community seems, of course, less clear. Essentially, if I was a surrounding community, or a potentially surrounding community, I would be reading this with the notion of when do I know whether I am in fact a surrounding community or not? Where in this timeline can I get a sense as to whether we are or not? And I don't think that's an easy answer, but that's because there's other moving pieces, many of which were discussed in the in the mitigation forum, because it's not necessarily geography, although that's a big factor, not necessarily just an abutter. It has to do with other factors like traffic and whatnot. But if we could at least mention something to the effect of that determination, which is incumbent on this commission.
But actually,
maybe
I don't, as I understand the process, a developer will be doing the same thing relative to a surrounding community as it must do with a host community. Host community is more important in a way, but a developer will make itself the first judgment about what it thinks a surrounding community is. And it will go to that surrounding community, or it will respond to that surrounding community when the community comes to it and say, yes, I consider you a surrounding community, and before I can fill out RFA 2, I need to have a signed agreement with you. So it's on the very same time frame.
But there's another step.
And then it comes to us.
No, there's another step for the surrounding community. If the developer doesn't go to the surrounding community, and the surrounding community thinks the developer should have, then after it comes to us, the surrounding community, would-be surrounding community, can say, Commission, I should have been a surrounding community. Right. And then there's another process that kicks in. Right. I wonder, picking up on what Commissioner Zuniga said, if two documents wouldn't, this is a terrific start, and I think this will be really helpful. I'd like to make some fine-tuning things that I'll send, but suggestions. But I wonder if a second document that's sort of a process document wouldn't be or an appendix to this that would be a sort of a process document that sets out the statutory criteria in a schematic fashion. Wouldn't be a helpful companion to this document. So this is a timeline, and this is the process, and you put the two together rather than trying to have one document do too much work. There have been a number of, we have one of our own that I think it needs to be simplified. There was another one that was presented by a law firm to one of the communities, and put together a schematic that would go with this. And I think the combination of the two would be enormously helpful too.
And to pick up on that point, one of the things the Collins Center has come back to us with is trying to do just that for us, is kind of lay out kind of steps that the local community needs to take. You know, need to have an election within 60 days, but no more than 90 days and things like that. So they might be able to help us put that piece of it together as kind of an adjoining document.
We're gonna talk about the Collins Center when I'm not here, but if you've got something that relatively quickly you could draft that you think that you would have, let's look at that. I was thinking, I'd like to get something out soon.
Yeah, I think that's right.
So, but if it's something quickly can be added to this, let's do that. But also, you know, whatever resources we end up bringing to the table to help municipalities could have that document like you were suggesting, Commissioner Stebbins. So whenever, if it's something that could be done quickly, let's add it to this, but if not, let's get this out and then have that come as a second piece.
I think that we can pick up from existing documents
Right.
fairly quickly.
Okay, great.
Rough schematic and.
I did borrow
Get it
from
out.
those documents when I was doing this chart.
Yeah.
So the other thing that I do put in here, I think I'm on the right, yeah. We have, at least I think we have, begun to package together the idea of an ombudsman who will have two functions. One is to serve, and we'll get to this in a minute, would be the point person for the bidders, or proposers, that need to work with state agencies to develop their proposal. We would have one point of contact in our office whose job it would be to facilitate that relationship. And there's another document about that here. That same person, I've been beginning to think, and I think we've talked about this, would have a similar skill set to the person who's also the single point of contact for the municipalities. So if you're municipality X and you don't know what you're doing relative to trying to figure out how to negotiate a host community, you call this same person, and that person says, okay, I know what your problem is. I can refer to you some stuff on our website. I'll put you in touch with this agency that we've helped, and here's a series of law firms and so forth. So that rather than publishing a list of 8 people that says, if you got this problem, call him, that problem, call her, cities and towns would know there's one smart, briefed, prepped person to call who can tell them what to do. So that's also, that presumption is in here that we would get that one person. And I just want to make sure we're all on the same page on that. I do have 2 ideas of such a person. And I haven't talked to either one of them, but I thought I would, if we're on this program, I talked about this with Commissioner Zuniga, that we might bring such a person on as a consultant for a while. We don't know whether we've got a full-time job here. We know we have 2 needs that are beginning to build up pretty aggressively. We could bring a person on as a consultant for a while, get it started, get the need met, see how it works out, and then if we think ultimately that there's a full-time position here, we could post such a position and hire such a person. That's kind of the way I was leaning at this point.
Just a couple of questions.
Yeah.
One is that person best suited to be employed by the commission or another organization that maybe we fund? Just.
Well, the way I've seen this is that people naturally think that we are in the centerpiece of this. So they want to contact us, and that's why we get all the letters and calls that we get. So having us be responsible, somebody that we are really under control of in servicing bidders and servicing municipalities well, I would feel good about having that person in our shop reporting to us. That person, as we've discussed for a host of other reasons, won't be the person who's given the information. That person's not going to go sit down in Brimfield and strategize with the town selectmen for the reasons we've all discussed. But that person will know where the resources are, and that person will be under orders not to give anybody the runaround, and will watch that person. So I would feel better about having that person who's the traffic cop, ombudsman, not the service provider, the actual service provider, be in our shop. That's the way I feel about it.
And as I understand, the ombudsman would also be managing the interaction between a potential developer and the other state agencies.
Correct. They would have both relationships. It would be the ombudsman for the developers, and it would be the ombudsman for the municipalities.
I mean, I think it goes without saying that somebody who's officially seen as part of the state government or state commission is going to have a better ability to interact with other state agencies than kind of a contracted third party. So I mean, to the argument of, you know, having that person in-house as opposed to.
Right.
I think it's a really good idea. We've talked about the desirability of doing that from the developer side, certainly, and trying to smooth a path through the regulatory maze that sometimes exists for all significant development projects. The cities and towns are facing a similar kind of maze, regulatory and other, and it seems to me worthwhile to have somebody doing both of those jobs and somebody located in the commission, because that's where everybody's turning. Despite the fact that we need to move, and it's highly desirable to move quickly, I would like to see a job description and a process for the person. Doesn't have to be elaborate, but I would like to see a job description for us and a process and then a decision. So we could get to that quickly. I think we'd be well served.
I hate it, but I agree.
I know.
I agree.
I share
No,
both of those.
no, I'm with you. You're right. You're absolutely right. And I will do that. That's a constructive suggestion.
I agree as well. I just have one small comment relative to the timing, and that is perhaps if we could highlight the process or the drafting for the regulations phase 2 as part of this process. It's implied here that is before April 2013, but how much may be relevant for us to at least mention, because communities should be communicated that in those regulations there will be criteria for the evaluation of ultimately of the proposal, and knowing when that will be might be very worthwhile for communities.
Can you just suggest language that you were?
Sure. It would be an interim bullet here in between May 2013 and October of 2012, I think. Because we'll also be drafting regulations for phase 2, presumably as soon as we're done drafting regulations for phase 1. That has its own sort of process, which we were just talking about. So as soon as those regulations come out, which is, again, before those RFA phase 2 solicitation begins, it starts to signal and communicate officially to communities.
Yeah, I think those are
of that evaluation process.
Well,
It's a minor.
yeah, I don't know that it's because we don't know whether it's. I mean, what we just talked about with the consultants for RFA 1 is that basically the day the publication, the regs are published, is the day the RFA goes out. I mean, there's no reason for there to be a time frame between the two, unless we fall behind somehow. Their assumption is that October 12th is when we would basically send out at least the slots parlor RFA. So
But you're talking.
there's not meant to be any.
Yeah.
But in phase 2, the same thing. There's not meant to be a window between the final publication of the regs and the release of the RFA.
No, I'm not talking about the final, I'm talking about the draft, or the earlier ones. So that
I see.
the earliest we can communicate to communities that, here's the way we're seeing the criteria, and then comply with all the public comments, et cetera.
I think this might be better in the document you're talking about.
Yeah,
The process.
I think we need,
process.
I think we need to do it one way or the other, because the regulations on the second phase are going to dictate what has to be in the agreement between
Precisely.
the town and the developer.
Precisely.
What the vote has to consist of, and those kinds of things. And we need to tell people now that they have to wait for that to materialize before they can safely move forward with that negotiating step. So I think we can put that in the flow chart to show.
Process document.
Yeah, in the process document.
Right, that makes sense. Good, I agree. Okay. All right, so we'll do some more work
on this, a little tweak, we'll do some tweaking on this, and we will probably add a process document, and then we'll have something to get out the door.
Right.
Hope sometime pretty
Right.
soon.
Soon.
And I will work on a job description and process for the ombudsman idea. Okay. 5D, okay. 5D, sorry, is the discussion of the protocol for managing the developer-state agency relations. Oops, sorry. This is the manifestation of the conversation that Commissioner McHugh and I had with the governor's office and several of the major secretariats. We committed this to paper. They have agreed. The draft, they got back to me later today with a very slight change. Instead of saying 2 weeks response, they talked about 2 business days or something, but they're very minor changes, which I'll send around. But basically, the governor's office is completely, and the secretariats, transportation, environmental affairs, economic development, are entirely in sync with this. So basically, what this says is that between now and the time that a developer becomes an applicant, you become an applicant when you pay your application fee of $400,000. Between now and then, any developer who wants to work on a project can have one meeting with as many state agencies, key contact people as they want to talk about issues involved in their proposal. After they've become an applicant, they can have as many meetings with state agencies as they reasonably need, and those meetings will be coordinated by our ombudsman with a designated single point of contact at each of the various agencies. So both pre-applicant designation and pre-selection as a licensee, all that process, they would go through us to interact with state agencies. Once they become a licensee, then they will interact directly with state agencies on their own. We'll be out of the process. It'll just be trying to fast-track a development project, as frequently happens with state agencies. So the key distinctions here are, key policy points are, one meeting pre-becoming an applicant, which is when you pay your $400,000 fee, and 2 is going through an ombudsman in our office. So, I don't know if do we need to vote on this? I don't think we do particularly.
Well, before we get to that question, in the post-license period, have we come to an end point in our discussions as to how that's handled?
No.
With the secretariats?
No, right. Do you want to go ahead and explain that issue?
Yes. The issue one of the issues we raised with the secretariats was what happens after the license has been issued. Because there are going to be various permitting requirements, no matter how much the pre-license conversations have vetted issues, those permitting issues are going to remain. So how do we think through and help now the city, town, surrounding community package that's been awarded the license move through this process efficiently? And Chapter 40D is a portion of the general laws now that allows that to happen at the city and town level, but it doesn't apply to all communities. That some haven't accepted it, and it doesn't include some of the secretariats, like the Department of Transportation. So the question is, can we work with the secretariats to create a process, a post-license process, to help with that? And that just hasn't been resolved yet. We haven't come to an end point in the discussion.
Right, and they've said they know it's still an open question. They're happy to talk with us further about it. I actually thought if we could move quickly enough and get our ombudsman in place, that person would be a good person to help us have that conversation,
Right.
and flesh out the process.
Right.
If it's the right person, that person will know a lot about expedited processes and so
Right.
forth.
Right.
If that takes a little while longer, then we can continue to do that ourselves. But we have agreed, Commissioner McHugh and I have agreed that that's an important priority, is to come up with a standardized, expedited permitting regulatory approval process, so that once the licenses are awarded, the developers can move ASAP down the road.
So with that caveat in mind, it would be, I don't know that we need a vote if there's a consensus that this is a good approach and that this is a good document, or that we have any comments to Steve about the document within a couple of days, and then we post it on the website and announce that this is what we've done and that we're looking for the ombudsperson to fill this role. I think that's sufficient.
Great. I guess I had the center, the conversation about the Collins Center under 8C, Bruce. So when we get to, that's the community outreach responses to requests for information. So when we get to that, I'll leave and you guys can do an update on that. Okay. Okay, charitable gaming, any status report?
Yes, just very briefly, Mr. Chairman and colleagues, we have posted on the website now a solicitation for public comment on charitable gaming, anything that anybody wants to tell us about charitable gaming and how it's working, how it's not working. I have, that was posted the other day. I met with Donna Hooper, the Lexington Town Clerk, who's the head of the Town Clerks Association. She was very helpful, very forthcoming in her views as to a couple of things that needed tweaking. Is going to talk to and send out a email to her members of her organization to get their comments. I've got another meeting with the lottery scheduled for next week sometime to get their views, and I've spoken to the Attorney General, and we're on track, I think, to have a comprehensive report by the deadline with some recommendation. July 31st is the deadline. July 31st, we become responsible for regulating those bazaars that are governed by Chapter 271A, Section 7, which are a portion of all the bazaars that are conducted in Massachusetts from time to time. And so the rest of charitable gaming, we don't have a responsibility for under the statute as of July 31st, but we are required to make this report by the 31st. So, and insofar as those bazaars are concerned, there are a set of regulations in place now that the Attorney General has promulgated that in all likelihood will seek to leave in place until we reach a more permanent solution.
And you're going to bring a proposal to us at
I
some
will.
point to
I
talk
will.
about, right?
Right.
Okay.
It'll be similar, I think, to the way we handled the Racing Commission regulations, leaving the existing regulations in place as we, depending on the recommendations we make in our report to the legislature, await further legislative changes.
Right. Okay, great. Item 7, finance and budget. Commissioner?
Yes. Yep. Just briefly, I submitted a memo for your consideration relative to establishing a threshold for approval of certain expenses, incidental expenses. This has a dual purpose to also start documenting or continue documenting the procedures, the internal control procedures. My recommendation is that for incidental expenses, we mirror a threshold in the public procurement procedures of $5,000, under which I would approve of those expenditures, even if they are unbudgeted. And going forward, when we establish a budget and approve a budget that I'm also working on, this threshold is less relevant because it would really be the contracting of services under whatever those thresholds may be, where approval is then the driving piece. So this is partially driven by the fact that we have not approved a partial budget for this fiscal year, and that's where I'm submitting it.
So we probably do want a motion for this.
Yes.
Right, do you want to frame it?
Yep, as I would like to ask for approval of my recommendation here, as stipulated in this memorandum, to establish a threshold of certain incidental expenses, under which such expenses will be approved by one commissioner and eventually delegated to a financial officer. Such threshold is recommended to be established at $5,000 for any particular expenditure.
And that the treasurer be the designated commissioner.
That's right.
Second?
Second.
Any other discussion? All in favor?
Aye.
All opposed? Nay? I mean, the ayes have it.
Thank you.
Thank you. Live it up. Okay, let's see. Public education information, I think we did discuss the June 9th. No, you were not here. You weren't here for the 19th because you were at the 19th forum. Was there anything
I was.
that either we or the public would be interested in on the June 19th forum that you attended?
You know, many of the issues were covered yesterday, many of the
Right.
same issues. It is more of a working group with members of the industry, and they have been working for a couple of years, and really what was discussed there are many of the same topics that we all heard about yesterday, and there were a couple of tabletop exercises completed there also. You know, just improvements to the programs already in existence in the state, additional locations for programs, especially in western Massachusetts, where there's not as many treatment centers, areas where people can go for treatment. But other than that, I think there was some new participants, me being one of them, in that working group. But, I mean, I think as we all found out yesterday, there's a great model right here in this state for others to take a look at with regard to the council. So I don't think that would be about it as far as the difference between yesterday and the forum I attended in Braintree on the 19th.
Okay. And the 25th, I think we were all impressed. If anybody didn't see it yesterday, I guess, in North Shore Community College, we had what turned out to be about a 4-hour educational forum on the issues of problem gambling. The emotional part of it was two recovering gambling addicts who talked frankly about their lives. And but I think, you know, it once again reminded us from an outside experts about the quality of the job the legislature did writing this legislation. You know, everybody talks about they addressed this issue with dollars and organizational structure that is as well done as any place in the country. And we have the resources to do research, prevention, intervention, everything under our umbrella in an organized way. And I think we all walked away from that meeting with a really, if we didn't have it before, really heightened sensitivity that this is not kind of ancillary to our job. This is central to our job. When it was well done and time well spent. Anything else about that forum?
One takeaway that I would underscore is this notion of establishing partnerships with the likes of the council on compulsive gambling, but other healthcare professionals, networks, alliances. I believe the second speaker on the second session talked a lot about partnerships and alliances, one where we really have a prominent role, and that's one thing that I think we should establish early on, soon.
Yeah.
I had 3 big takeaways from the meeting yesterday. One of which Commissioner Zuniga just touched on was the gentleman from Iowa talking about his roles and responsibilities, but there wasn't a clear connection that he had. It was more informal in terms of working with, I guess, what would be Iowa's counterpart of us.
Right.
And I think that's important as we go forward to have those allegiances, not just based on who the personalities are at the table at the time, but more in a formal way. You know, I was impressed with the discussion about the self-exclusion. I couldn't get the sense of whether that seems to be the you know, the trend of the day or the process of the day for an individual to try to remove themselves from harm's way with respect to their gambling addiction. But I think that could be a key piece in terms of how we look at the licenses that we award. And then I think the other piece of it was the push to get you know, the professionals who are dealing with the addiction to really identify those three issues as they begin to screen people, and really pushing for that to be part of you know, the work of the social workers and the people who are out there, you know, dealing with people with other addiction issues to see what impact gambling falls into that. It's, you know, again, I don't know the level of work that these social workers do, but you know, adding 3 additional questions to their screening, I think, makes a lot of sense from our work, but I don't know how it fits in with everything else that they're trying to do.
I can tell you from other experience in state government that will not be easy, because all those people who are already doing screening intakes or service treatments for addiction or drug abuse or whatever, A, they feel swamped, B, they've got strict union regs, you know, C, the people don't want to answer the question. I mean, that's not easy. Having said that, it looks like it makes all the sense in the world, and that's something that we could start, you know, we could get Secretary Bigby from EOHHS is the trustee, in effect, of the Public Health Care Trust. We've come up with the money, but she has more say, I think, than we do on how that money is spent. I think we could have a meeting with her and John Auerbach, the head of public health, and others soon to start talking about what kinds of policy work would it take and negotiations would it take to get that kind of collaboration in place. So I think we could start that sooner than later. And I know her, I'll take the lead on putting together a meeting with those folks to talk about that. I think that's a really good point.
And in that venue, if we could at least think or map out a potential memoranda of understanding, for example, with those agencies, you know, similar to what we're doing with ABCC.
With law enforcement,
and law enforcement. I mean, it could be less formal, but I don't think it's less relevant to really establish what approach could be, what we could put in regulations, for one, and what procedures could be monitored at the casino when they're operational.
I agree with that, but I, and I know you, reading one of the news accounts today, apparently are thinking along the same line. I came away from that impressed by how serious and devastating a problem it is. That's not saying anything novel, but how close it is to the heart of what we're doing, and that it is worthwhile, I think, thinking about having a person who's part of the commission who has a group devoted to that, not only to keep in the forefront the importance of the issue and the problem and the energy that has to be devoted to its resolution, but also to keep an eye on the kinds of things that we heard about from the 2 people, Scott and Jody, who testified about what they'd gone through and testified about what they sensed were was the assistance. They didn't try and lay off the blame, but the assistance they received from casinos in feeding their addiction. And somebody on the inside in a regulatory body can not only be looking for ways to help the individual check the problem, but also to keep an eye out for and be close to the heart of the power to deal with the kinds of practices that they at least hinted at. The Pennsylvania Commission has a person who is at the high director level who's in charge of the Office of Problem Gambling or the Office of Compulsive Gambling for the Pennsylvania Commission. And I think at some point we ought to think about that in our organization chart as well.
I agree with that completely, and I've been champing at the bit till we get some of these draft organization charts from the consultants, which we're going to talk about tomorrow. And I have the same reaction. And if you think about, I mean, it doesn't have to be tomorrow, but the task of trying to work out relationships with other social service agencies, that's a really big long-term, if it takes union negotiations, that's a really long-term job. And thinking out what our strategic plan is gonna be. What is our compulsive gambling strategic plan gonna be? You know, how early in the game does the inoculation advertising start? Are we gonna have a hotline? You know, on and on and on. That's a big project, and there's none of us can handle that at this point. If we had a bunch of meetings with social service agencies and we set up a task force to start working on it, we don't have anybody to go to that task force. So I'm inclined with you, I think, to think about getting a director-level person to head up that work sooner than later. So let's talk about these organization charts, but I think we're.
It might be a position that could be funded, I mean, at some point through the $5 million that goes into the Public Health Trust Fund.
Yeah.
I think you have revenue options to cover that as well.
Right. Okay, good. Well, I think that's a.
Yeah, I would agree, that's an important position.
Yeah,
And,
okay.
I mean, I'm more convinced now after having attended a couple of sessions. And I agree with you, I really want to see some organizational charts. That's how you really have to.
Right.
For me, that's how I think about what the responsibilities really are and kind of plan what we need to work, the areas that need the most attention, so. You'll share that with us after you work on it tomorrow?
Yeah, they wanted to have a meeting with brainstorming very different organizations. Apparently, we don't exactly know why they wanted to have a pre-meeting, but for some reason, they wanted to have a meeting with one or two of us first before they brought it to the public meeting, so presumably next week we'll talk about it.
Right.
The thing that, as I mentioned at the meeting yesterday, that was very troubling is this role that at least these two addicts felt the casinos played in inducing them to do what was clearly contrary to their interests. And I've worried all along about the extent to which problem gaming is central to the economic model of gambling. You know, if, in some of the numbers, I asked, what's his name from American Gambling Association when he was here, you know, Frank Fahrenkopf, you know, what percent of revenues comes from problem gambling? And he said he didn't know. Rachel Volberg immediately said there's lots of studies about this, and it's 25, 35%. But it's just, you know, where's the rubber? The casinos can't afford to give up 25 to 35% of their revenues. So how deeply committed are they going to be to really keep problem gamblers out of there? And it's just a really interesting question. It depends on what you consider a problem gambler, and you know, clearly the pathological cases, the Jodys and the Scotts, probably most people would believe that we ought to try to help them protect themselves. But anyway, it's just a really interesting question. But I think we to find that line to walk, we're going to need to be really smart and really thorough and have some real serious lead time to figure out how to do that, how to draw those lines right.
And a relevant topic on that, I was also struck by the notion that somebody brought up the point, actually, two different people brought up yesterday relative to it would be easier to monitor problem gambling in the context of online products, because all of that information is, well, it's data and it's virtual and could be whatever, sorted or identified or put into a logarithm that measures hours or whatever it is they measure. And whereas in a casino, that's less clear. And I see perhaps a nexus relative to what could be done in a casino floor to identify patterns or whatever it may be relative to that action, the action of really gone above the mean or beyond what most of the other population does.
Right. Just one additional point. I can't remember the presenter, and hopefully we get their presentations, but there was somebody who would come up with, these are all the things that were tried to impact problem gambling. And they started off with step A, but the unintended consequences were step B.
Yeah,
like limit somebody's time on a slot machine. Well, then you just start playing faster with bigger bets as your time starts to run out. So that was an interesting piece of the presentation.
Yeah. And that's all the more reason I think why we need to start this early, so we've got the time to really think these things through. Okay, I think we know where we are on that. Item C, 8C, community outreach responses to requests for information. We've sort of ended up talking about, this is kind of the same topic as technical and other assistance to communities, 5C, and I'm not sure that I've got these divided up right, but basically we've decided to have two resources. One, we've tentatively decided to have our own ombudsman, who will be sort of the traffic cop. But we've also decided that we could spend some money to provide resources to outside agencies who would actually do the work with cities and towns. And we've kicked that around a little bit. We've got some ideas in place. One of the organizations that we would consider retaining to do that is the Collins Center for Public Management at the McCormick Graduate School, which is where I used to be dean. So I've decided, I don't think it would affect my judgment, but it might, and certainly it might appear that it might. So I'm going to step out of the room when we have that conversation. Just anything having to do with who do we retain to provide these services and what do we pay them is a conversation that I don't want to be a part of. So I'm out for a few minutes while you guys get an update on that topic, and I'll be back.
Actually at the back of your packets.
It's item number 9.
Thank you.
I think we can, let's quickly go through you see in front of you a draft proposal to the Massachusetts Gaming Commission from the Collins Center for Public Management, UMass Boston. This was initially coming on board. We had an initial conversation with the Collins Center about our overall goal of how do we support municipalities. Again, we've talked about it a number of times that some municipalities are better staffed, depending on the size of the community, to look at planning issues, capacity issues, have negotiating services available to them for negotiating a host community. So we had an initial conversation with the Collins Center back in, I'd say, late April. But I think as this commission began to meet and have our regular business meetings, and we started to get inquiries from communities across Massachusetts, especially those that have been, that are potential host communities, it began to gel our thinking a little bit more about where we saw some opportunities to be helpful. So after our community mitigation forum, which some folks from the Collins Center attended last week, they sent the scope of services, number of suggestions, obviously, as you read through this, with respect to how they feel they could be helpful, both to the commission as well as to a potential host community, documents, reports they want to begin to prepare, some ideas in terms of collecting best practices from everything related to economic development, local hiring practices that other jurisdictions have used, even coming up with best examples of host community agreements, in terms of being able to pull all this information together, be a resource, and hand it, and be able to make it available to, again, communities that may or may not see themselves as needing the help, but again, we want to put it out there that we want to be as helpful as we can. And I think a lot of this information, and once we can finalize a scope of services, and we're looking beyond not just what the Collins Center might be able to offer, but to some other entities as well, be able to couple that together and put it out in a letter, and probably include it in the draft we looked at previously. As you can see, this initial scope does not have a price tag with it, because they've broken it out into a series of tasks. As I've looked through it, looking at the state regulatory requirements, again, we're reaching out to a few other entities to be potential partners that may be better experienced at handling some of this work, or at least able to conduct the work potentially faster than the Collins Institute. But I don't know if you just want to invite some feedback on the scope to see if there's anything that we're missing. I mean, what I'd like to do within the next week is to circle back with them, give them some feedback as to the scope that they've provided us, see what makes sense. Again, we have a couple other meetings coming up with some other potential partners who might be interested in tackling a piece of this work. But certainly everybody's feedback would be greatly appreciated if you want to do that now or you want to submit that to me, whatever works best for the rest of you.
I have one question and then a comment. Does this proposal envision giving individual assistance to individual cities and towns? Or is it more of a series of how-to checklists, case studies, and the like that would be posted someplace that would be a general resource for citizens?
It's a good question to ask, and I think it involves a little bit of clarification. I think there's some public, there's some general documents they pull together for a host community to consider. When you look at potential public service impacts, I don't get from this scope of services whether that's meant to target an individual community, whether an individual community would want to go to the Collins Center and ask for their assistance, or whether that's, again, they produce kind of a broad informational document for kind of a checklist that a community can run through. But that was a question I had, with respect to that potential public services impact, how kind of on a client-by-client basis this work might be done. But most of it is relatively broad. I think a lot of it is just pulling together a lot of good best practices for communities to consider and go to a public document where they could have some assistance.
This is like a guide, I think. That's what I'm reading out of this. It's a guide for the assistance that's out there. So they would want to prepare this document. That's what they're proposing, right? They would like to do the research and.
Right.
Yeah, I had a question, and I know this has been discussed a little bit, but how would this effort correlate with the notion of the ombudsman
I had
that
that
we
same
have
question,
as well?
yeah.
Is it contemporaneous and there's some collaboration?
Right.
Or,
And again, I mean, that's the first bullet really under the anticipated regulatory processes. They may be looking at a broader statement. Again, I haven't had a chance to sit down with them and kind of walk through the scope. They may have questions about whether it's a broad document, here's everything you should consider as you consider this process, or is it more germane to the one-on-one role that we've talked about the ombudsman having?
Right.
Again, looking at this, it's kind of a starting place. I think there's some good ideas and suggestions in here. I need to circle back with them and begin to piece out, and again, we're having other conversations with other state entities that might be better experienced at tackling some of these pieces, one of those being kind of the development questions and
Right.
some of the local service impacts as well.
Right. Yeah, I was going to touch on that because just from a procurement standpoint, having other these agencies are not profit driven, but coming from the angle of having different opinions or different proposals, different approaches, may be very beneficial for our process, and be able to then scope out. So I would be very interested in those additional conversations that you're talking about,
Okay.
to put these in context.
That was going to be my comment too, that a process for getting other proposals.
Right.
And they don't have to be mutually exclusive, but would be enormously helpful to the end. But in terms of the ombudsman, it seems to me the ombudsman directs, is sort of like a traffic cop. The ombudsman's really specific, and that the utility of this could really be, or this or whatever proposal comes out of it, could really be a series of model agreements, a series of model RFPs, a series of model whatevers, that cities and towns could and their attorneys could build off of, because all this stuff is brand new. And that would be an enormously useful service. And in that regard, it might well be helpful for the people submitting it, whether it's the Collins Center or others, to touch base with the organizations of selectmen and others to find out what they want. Because there are a number of select boards that have contacted us already and have asked for help in drafting various kinds of documents, so.
Yeah, I mean, some of the work in here does look like, even you get down to, best practice review, compiling best practices from other jurisdictions, how they make it work. Draft agreements are certainly something that, a local solicitor could look at and say, this is a great document, it works best for our town.
Right.
Or it isn't. But doing a lot of that search for the best practices is time consuming. So, again, my goal with this going forward is schedule time to sit down with the Collins Institute, kind of refine the proposal, answer some of the questions. Again, if you look over this in the next day or so and have some additional questions you want me to raise, happy to do that. And again, we can have a conversation about soliciting, additional inquiries who might be able to also do the work. But we're also having conversation. Enrique and I are meeting with the folks from Mass Development to see what support they might be able to give us on a broad base or on an individual host community basis in terms of understanding impacts around development costs, and size, process, et cetera.
All right, sounds like a good plan.
The other piece of it, I guess we'll talk about that while the chairman's out of the room too. The research agenda, because we have received.
No, I think he can come back for that.
Kenny?
Yeah.
Okay, all right.
I know. Oh, I had to wait a lot longer.
She had to wait a lot longer.
Like I was a bad boy. Okay. Report from the Director of Communications and Outreach.
Well, we hadn't hit the
Oh, sorry.
research agenda. You
That's-
wanted to be present for that.
Well, no, that's 9.
That's further now.
Oh, I'm sorry.
Yeah.
I'm sorry.
Yeah.
Sorry.
I'll be quick.
That wasn't a hint.
Hello, everybody. At this point, I'm still working on a lot of the things that I've been reporting out on, because a lot of these things are a process, and also just sort of figuring out what our needs are. I have 3 meetings set up for the week of July 9th with various companies that I've met over the last couple of weeks and spoke to in regards to how to build out the brand and the website. I met with mass.gov yesterday, just in terms of what our options are in working with the website. So I think that one of the things that's becoming increasingly apparent, even with our problem gambling forum yesterday, the memo that you created about mitigation, we need a really strong information portal where people can go and easily find information. And every day, and even with the charitable gaming press release that we put out 2 days ago, the needs that our consultants are informing us in terms of what the racing qualifications are, what the notice qualifications are. We just need a really strong site. So, like I said, I discussed with mass.gov yesterday what our options are for the site. I'm also meeting with 3 different companies the week of July 9th to hash that out a bit and to see what our options are. Obviously, there's a sense of urgency to it, so I will move the process along as quickly as possible. But I just have a lot of ideas of what the needs are. I'll probably visit also with each one of you before I have those meetings to get a sense of what you would like to see represented on the site as well. So that's, a very high priority for us right now. Got a process in place for announcing racing hearings, so that actually was easy enough to put together so that the next time there's one coming up, it's just a matter of getting it out to the right people who've been identified, just to make sure that the notice runs in Globe and Herald to meet the requirements. Again, just put out the charitable gaming request for feedback this week, and again, I'll just continue to follow up on that. I continue to try to find creative places to solicit the most feedback in who those individuals are. One of the things, and I hope to be able to see some of our social media outlets be able to do this soon, is, for example, when you were talking earlier about, is it Lexington?
Right.
So I think one of the things that we might want to start doing, and social media will give us the opportunity to do that, is when we get down into the weeds on regulation and we have questions about certain things, is there an opportunity to poll the community there? But we have to be specific about that.
Right.
So, so if we put out a general request for feedback in the beginning, when do we get to a point in the process where we can sort of narrow down what the community ask is and get down and to really help us make a decision with A, B, or C? So I want to make sure that, again, when we put this information portal in place, if you will, that it has polling capabilities and things like that for when we start getting into the public hearing process. You know, again, maybe there's like a wiki pages type of sharing mechanism for community draft of regulations. But we just really needed to be interactive and inclusive for community feedback. I think it's doable, but we just have to it will be very sophisticated.
Right.
So that's what I'm really busy working on right now. And again, as I mentioned, the charitable gaming press release that went out, the racing notifications that went out. And again, I think that with the last 3 weeks of forums, I'm experiencing just a clear increase in just the level of inquiries coming in, the level of media questions coming in. I'm feeling a lot of momentum of interest with that.
Great.
So it's been
That is
great.
great. I think the idea of a really robust, useful, functional website is just a great idea. I mean, it's what all what all drives private industry, drives a lot of segments of government, and it's great. It's great.
Yeah, and there's a lot of examples that are out there right now of people that are doing similar things, like San Francisco has a project going right now to build better streets, and they put this really interactive website together that's really caught my eye. So I'm just researching those types of initiatives that other cities and states have taken on for this exact type of community engagement process. So they're out there, and it's just a matter of obviously tailoring it to our specific needs.
Great.
Okay.
Great, thanks.
Thanks.
Okay, speaking of engagements, I don't think we have anything. Does anybody have any in the next week or two? Commissioner Stebbins, discussion of Western Mass Forum, our next forum.
Sure. At our community mitigation forum we had out in Framingham, one of the attendees is Tim Brennan, who's the executive director of the Pioneer Valley Planning Commission, kind of covering 3 of the 4 western Massachusetts counties. He approached us and expressed an interest in helping us organize a forum out in Western Mass, primarily to discuss mitigation concerns and issues related to that. I followed up with Tim this morning, talking about additional topics being workforce development, which he thought was a a topic of interest, and I know it's a topic of interest that was raised by Senator Kendaris when you met with her, as well as the tourism piece. And Commissioner Zuniga and I, who have been out to Western Massachusetts a couple of times, those are three of the hot topics, I would say, for that region, at least at this point. So Tim and I spoke. He will work on bringing together folks in the mitigation piece. I was at a meeting yesterday with the directors of all the convention visitor bureaus from around the state. So the State Office of Travel and Tourism and the local convention visitors bureau offered to help us address that topic. And the workforce development issue, I think hopefully it'll be timely because we know that President Messner from Holyoke Community College wanted to come back to us with kind of a refined and expanded proposal about what their plans were. So I think it all works out. Looking at probably mid to the end of July to get it all squared away. I did put in a call to Senator Kendaris' office because I know she was interested in having it hosted at Western New England University. So we'll keep plugging away.
So tentatively, late July, early August, is that what you're thinking?
Yes.
Okay. Good. Would it make sense, or is it premature? I mean, we're constantly reading about potential sites, and in the case of Suffolk Downs, for example, I've passed it a million times. I have some sort of sense. It sort of helps me crystallize. But the Western Mass sites, I don't have any clue, where they are, what they look like, and none of them is teed up yet. I realize we don't have any applications. We're a long way from that. But just from a purely personal way, I could sort of visualize what's going on when I'm reading the clips and thinking about this, and people talk to us about stuff. Would it be a good idea or a bad idea or a neutral idea if when we were out there, if we just took an afternoon and drove around and looked at all the locations that are being talked about? Anybody have any interest besides me?
Yeah, I would be interested, just to put a mental picture to what we read about. I'd be very interested in going to all of them,
Yeah.
to be equal opportunity offender or
Right.
whatever the case may be. But yeah,
Yeah.
might be worthwhile when we're out there.
Another field trip.
Yeah, for the field trip, right.
Well,
I
I
would-
don't want to assume my usual negative
Grumpy
role.
stature, right.
Grumpy role. I wonder if we're not, I wonder if there aren't some that we don't know about, and some that are just beginning to percolate. And if a road trip like that might have those people feeling that they were left out. If we were going to do that, and it may be a good idea, after the
Applications.
RFA
Right.
1 came in, so we
Right.
had a feel for
That's a good idea.
what might be a better time, besides the leaves
The
will
leaves
be
will
out.
be out.
And
All right.
some apples and
I think that's
cider.
I think that's.
I
He's
don't-
just making that up so he's not such a grouch. Doesn't get perceived as a grouch.
Well, I'm a little worried that I agree with the judge on this one. I'm too young to be qualified as grumpy, I don't know. But
Nobody was suggesting that.
thank you.
Go ahead.
Or about,
No, I agree. I'd rather wait until there was a formal place in the schedule or a formal place in the process, because I think some sites are still materializing and others may not come to fruition. We probably won't know until that RFA process. But
I think that's a good way to do it. Let's do, maybe Janice, if you could make a note too, just to think about, after the RFAs, we'll plot all the people who have made applications and do it then.
I mean, I somewhat like the idea, and I go back to this, I don't want the conversation that we have with a potential applicant to be at the finish line. I'd like to see it somewhere injected in a formal way before that. And that might be the opportunity.
Okay. And obviously, for sure, Elaine, you know, it's an opportunity when we go out, if it's late July, early August, to do a serious media tour while we're out there. Okay, item 9, research agenda. We talked about maybe having a vote on a grant. I think we probably won't do that. But there is a memo here that lays out in some detail what Commissioner Stebbins and I have been thinking about. You know, the long story short is that there is not very much really good research on what the socio and economic impacts are of interjecting casino gambling, expanded gaming into a community. There's lots of different studies, and there's snapshots, and after lots of retroactive looking back, and so on and so forth. But almost nothing in the way of a really, really academic quality study that has a really good baseline snapshot before the introduction of the new variable, and then a long-term study of what happens to the whole range of things. Compulsive gambling is clearly a big part of it, but all the other things that we've talked about and heard talked about home values, domestic violence incidents, job generation, all of the various things that can be affected for good or ill by this kind of a change. And the legislature has asked us, told us to do such a study. How well thought through the idea they were, I don't really know, but they have a major interest in a research component. And the more Commissioner Stebbins and I talked about it and heard about it, the more we thought this is an opportunity to do something which would be very, very important for policymakers and other folks in Massachusetts, but would actually have real serious data that could be used nationwide, worldwide, as gambling is becoming such an increased phenomenon across the world. So our instinct is to really look at least for starters, look at this really big picture. And if it turns out it's infeasible for one reason or another, then we can pare back to priorities. But with everybody's permission, we're interested in pursuing this further.
Yeah, I mean, to make a reference to the legislation, I think the legislature in spots relative to problem gambling was pretty clear and definitive about a lot of the information they wanted to collect. There is a requirement in the legislation that we have some of this initial research work done within 2 years of the passage of the bill, so that would put us in November 2013. We received a kind of a proposal from University of Massachusetts Amherst School of Public Health talking about the problem gambling side. I think there's addition, as we've talked about, kind of repeating ourselves here, but we've talked about a lot of this baseline information. And again, having it a good jumping off point, because every year, the commission, with the advice of the Gaming Policy Advisory Committee we're going to set up, is going to come up with a research agenda for us to follow and have some great baseline information. And it may be tucked away in, other state agencies in terms of what that baseline information is. Following on the commissioner's memo, some of the topic areas we want to develop a baseline on, I'd like to share that with some of the people that we had at the Economic Development Forum in Worcester and say, does this look good? Are we missing something?
Right.
Tell us what else we might include. And on the problem gambling piece, it might be worthwhile to share our suggestions with the folks that were involved in yesterday's forum.
And you talked about ramping up this study from the casino, from the Canadian group,
Right.
Under the economic impacts does have tourism, but you were talking about maybe ramping tourism up as a bigger feature of it. But
the legislation talks a lot about gaming having a positive impact on tourism, and I know tourism has a person who's specifically charged with collecting data and research on their end, but looking at what some of those marks are, is it head count, is it hotel, motel, tax receipts, what are some of the good measurements that we need to establish that baseline?
Would we select one region to conduct this study?
My thought was, you know, I think we need to take a statewide snapshot. I think once we figure out where license applications are gonna be awarded, we could boil down a regional snapshot, and really be able to drill down into the nitty-gritty, because I think that's where, you know, crime statistics, unemployment statistics are all can be focused down at that, you know, minuscule level.
I think we talked to the researchers about too, just, you know, we try to understand what are the research questions we're gonna we're trying to get answers to. And once we're clear on that, then we figure out, okay, what methodology is required to get there.
This is a terrific idea and a great opportunity to do it. Could these researchers piggyback on any of the existing, or would they be planning to piggyback on any of the existing organizations that are out there? The Southeast, whatever, SPREDD, however you pronounce that acronym. The Southeast Regional Planning Commission, for example, has now in place a survey of all of the intersections in the Southeast region with respect to a variety of factors, the traffic through them, the number of accidents per intersection, the length of time it takes to get through them at different hours of the day. And I suspect that the regional planning commissions throughout the state have that kind of stuff. And I bet you they also would be willing to work with researchers if we got them to look for other things and to capture other data in their regions, to really mobilize the capability of the researchers and us ultimately to take a very accurate snapshot of a lot of factors.
I couldn't agree with you more. Again, I think that the problem gambling piece of the research is defined methodology and kind of survey instrument that they need. But I would also be interested in again, partnering with somebody that does an assessment of all that factual data that's out there. You know, we know we can go to the regional planning agencies for a lot of the regional information, right down to, you know, what traffic, you know, what intersections to avoid. You know, we can go to, you know, hopefully the State Department of Labor to look at unemployment, again, buried down in each community. Housing prices. I mean, who's going to help us take an inventory of where all those facts and information are, so we can establish that baseline and look how they move over time.
Great.
Are we thinking about one, engaging a group for a big research project, you know, one where it's not only the problem gaming or gambling and that baseline study, but additional aspects like what we're discussing relative to inventory of businesses that really have to do with economic impact. And the reason, and where I'm going with the question is that there's huge variability in terms of what data could be collected for the same purpose, which results in huge variability in terms of cost. I'm thinking in terms of first of all, procuring these, but also perhaps, which is what you were alluding to, Mr. Chairman, whether in order for us to define it, just define what we're going to do before we do that, we need to spend some money on some researchers themselves, helping us essentially scope out that agenda. Right. Is that sort of what we're discussing, or in terms of approach?
Mostly what we were looking for right now was just to make sure that everybody is in agreement that the gist of what we're talking about here is the right way to go. If the sense is yes, and I certainly get that it is, then we'll do a little more work on this and tee something up, and then come back to you with a specific proposal on, you know, what next step is required. Okay. And that may well be one of
the options.
Yeah, right. Okay, great. I realize I forgot something because I left the room for 8C, but I have in the file, you have in your file a letter from State Rep Keiko Oral. And she has asked that the towns of Lakeville, Middleborough, and Berkeley want to meet with us. So a state rep has written us and asked us if we would meet with some towns to talk about how they look out for their interests. It's the second paragraph is the main issue. So it's in southeastern Mass where everything's going to be governed by the compact. I hate to say to a state rep, no, you can't bring your constituents in to meet with us, but so I thought this is one that falls under this category that Commissioner McHugh has set up about some requests for help are going to be such that we ought to talk about them here. So I'm wondering what everybody thinks about this.
I'm not sure that we can give any substantive answers to the questions that are likely to arise. On the other hand, it doesn't hurt to talk to people as long as they understand that we don't have the power at the moment to give them substantive answers. I mean, that may sound sort of frivolous, but just the process of talking, seeing what's on their mind. I've talked to people in Lakeville, I've talked to people in Berkeley, and their concerns are manifold. And I've told them before that we don't have a lot of answers at this point. But if it would be helpful to bring them in, or even go down there and meet with a group of people. They're very active communities, and it seems to me it would be a worthwhile thing to do, and invite a representative Oral to be there and go down and have a meeting with them.
Yeah, if this were even a commercial site, we wouldn't have much in the way of answers.
Right.
But on this one, we have zero in the way of
Right.
answers. So
Right.
I think that's a good approach, and I think maybe I would just call her and say, I want to make sure expectations are set right. But if they are, and it would still be constructive to talk, and then we would be happy to do that.
Right.
That would sets a precedent, obviously, that we could get calls from other reps and senators. But I think that's a precedent we should be comfortable setting, as long as they understand the parameters, as you said.
Right. And it may fit into the Speakers Bureau kind of thing that
Yeah.
Elaine is working on
Yeah.
now, and it may turn into something that fewer than all the commissioners could do periodically.
Yeah.
But this is a group that's been very active and very concerned down there, and they have unique problems, and
Right.
at least we can talk to them about their problems and think outside the box and see if there's things we can do to help.
Yeah.
She does mention that her hope is that this meeting takes place before final compact is negotiated. I'm not sure, obviously, we don't quite know where that is in the process, but.
Well, that's the genesis of being able to help or not.
Right.
But that's part of what Chairman Crosby could talk about.
Right.
She attended our mitigation forum, she was very vocal.
Right,
Yeah.
Yep.
right.
Yeah, I've seen her several places.
Yeah,
where
very
she's-
thoughtful and very
Yes.
concerned. and
Yeah,
so
yeah. Okay, I think that's good. I think, so I will do that. Anything else? I think we did it. If there's no other business, I would entertain a motion to adjourn.
Make a motion that we adjourn.
Second?
Second.
All in favor?
Aye.
Thank you all very much.